Right, good evening, ladies and gentlemen. The computer clock says 6, this one says about 2 minutes to, and mine says 1 minute past, so I think we'll make a start. Welcome to this evening's Planning Committee. My name's Councillor White, John White, and on my left I have the Acting Vice Chairman, Councillor Baker. The other councillors who are members of this committee are sitting on the 2 sprigs either side, and they will be the ones that will be debating and voting on the applications this evening. On my immediate left and right are the TDC officers, including Head of Planning and the committee solicitor. This is a formal committee meeting, and it's very important that the councillors can hear both the presentations and the debate, and therefore I'm sure you will remain quiet and not interrupt the speakers. The order of business tonight is no different from any other. Each presentation or each application will have an officer presentation. Then we'll take any public speaking. Those who've indicated already that they wish to speak. And then we shall have any further comments by the officer. And then finally, committee members will ask questions, debate and vote on the application. I should add that this meeting is being recorded by the council. So let's turn to the agenda and we'll start with apologies for absence.
Thank you, Chairman. Apologies for absence have been received from Councillor Heaney and there is no substitute for her. Thank you.
Thank you very much. And colleagues, we have tonight 2 sets of minutes to go through, so let's take the items of the meeting on the 30th of May first. Are there any alterations, omissions or anything that anybody has seen on these minutes? Or if not, can I sign them as a true and correct record, please? Agreed. Thank you very much. That I will do. And that then takes me to the minutes of the 6th of June. And the same query arrives there. Any alterations, omissions or anything that has been spotted on those minutes? That's proposed and seconded and agreed. Right, I will sign both sets of those. Thank you very much. So now, declarations of interest. Those of you sitting on the committee that have any declarations of interest to... yes, Councillor Everett.
I'm seeking some guidance here. Application 1800681 detail, A3 on the agenda, regards an application that was before us some time ago and a change of condition. Most, if not all of us, were involved in the decision-making of the first application, so I need advice from the solicitor as to whether we are all predetermined or not. Please.
It's obviously come back as an amendment to that application, but as a fresh application with the extra information as to the reasons why there's a change to that particular condition. So the same rules of predetermination apply. It's how you each approach it on the basis of the information before you tonight, providing you come to that with an open mind and have not brought yourself here predetermined, then you are able to sit. You've all got to make that decision, and you've got to remember that it's also about the perception. So if you've been on another site visit today, I understand. So you've looked at the site afresh, you've got the fresh information, so you're entitled and able to determine the decision tonight. But you obviously need to, if you feel predetermined on it, you need to declare that and remove yourself as you would normally.
Thank you for that. I don't feel predetermined by that because I feel able to take the information that's brought to us this evening, and I would advise all of the other members to say much the same thing if they feel that that was appropriate.
Right. Councillor Benison.
Thank you, Chairman. With regard to planning application, item number 7, A4, 18-00320 for the cliff slope, I'm a resident of Holland-on-Sea, but I'm not predetermined. Thank you.
On A1, land north of Tokely Road, Frating, I have a daughter who owns a property on the existing Tokely Road, but I am also intend to stay and debate this item. I am not predetermined in any way, shape or form. No further declarations? Right. In that case, it takes us straight to item A1, which is on page 13 of your agenda. It is the planning application number 18/00194. It's a full application and it's for land north of Tokely Road, Frating.
Chairman,
Mr. North.
thank you, Chairman. As the Chairman noted, this is an application for, is in fact for 67 dwellings, land north of Tokely Road, Frating. Members will be aware from their reports that there has been previous history on this site. It was allowed in on appeal originally, and there was a subsequent detailed scheme for 49 dwellings a couple of years back. And this is a revised scheme for, as I say, 67 dwellings. This is the site itself. Again, members will have seen the site this morning at their site visit. You have the existing estate to the south, which is actually Tokely Road itself. The access leads from the main road further to the south. You have a small side access at this point to the west-hand side of the site. That's currently an informal, basically pedestrian access at present. That will be retained for that purpose if the application is allowed, and it will be used as a cycleway and pedestrian way. This is the site itself in terms of the aerial view. Again, you can see the link from the A133 via Tokely Road and then into the main access point where the arrow is shown. You'll note there's a commercial development to the east of the site, and obviously you have further residential development to the west-hand side. Just some photographs of the site, and again, you'll have seen this morning. This is the existing hammerhead, which will lead into the main site access itself. You have an existing open green to the right-hand side of this site, which currently serves the main estate. This is just looking through the existing estate road itself on the approach to the main site entrance. And again, looking from the western boundary across the site to the southeast. So again, you get a sense of the nature of the site. It's relatively flat and on a similar level to the existing development on Tokely Road. There's the site looking west across the site towards the east, and again you can see the commercial buildings to the east-hand side of the site, and again just the open nature of the existing site itself. This is the pedestrian or the existing access way I mentioned earlier. As you can see, it's relatively narrow. I think there was some mention of possibly having this as an access for construction traffic. I simply don't think it's wide enough for that purpose, and so it's not being pursued for that, but clearly it can quite clearly be used for as a pedestrian and cycleway. This is looking at it from the other side. Again, I think this probably highlights the narrowness of that opening. There's an existing car parked in it at present, but it's not a particularly wide opening. So this is the proposed layout. As I've noted, it's a full application, so we're looking at a detailed scheme here this evening. The majority of the properties proposed are two-storey in nature, two-storey dwellings. In the top left-hand corner and the northwest corner, you have 4 groups of maisonettes. So there's a total of 8 maisonettes in total situated to the northwest corner. To the southwest corner, you have 2 bungalows at this point, which takes into account the relatively narrow distance between the rear gardens of existing property and the proposed dwellings. So they're kept as 2 bungalows. You'll see the main road into the estate itself. simply as a main circular route with shared access points serving cul-de-sacs to the south and to the northwest. The existing village green is expanded to now include this area as village green as well. You'll perhaps also noted there's an existing band or buffer of trees along the existing southern boundary, and that will be retained obviously in place as a separator between the existing development and the proposed. Just one point to note, you'll see the layout of the proposed dwellings keeps the flank walls of the proposed dwellings side on to the existing dwellings to avoid overlooking. There will be a permitted development rights removed for first floor windows in terms of there'll be a need to retain those as obscure glazing on the flank walls of those properties. So there'll be no direct overlooking of adjoining properties. You'll note the existing properties to the west have relatively deep gardens. As such, there's no issue in terms of overlooking or loss of amenity between the proposed dwellings to the west side of the site and existing dwellings, and certainly no impact in terms of existing amenity in terms of other dwellings on the site. This is just what provides a bit of site context. So again, you can see the existing development on Tokely Road itself, the proposed development, and the commercial buildings to the east, and residential to the west. You'll note the now larger expanse of green space, which can be used obviously by both existing residents and new residents of the site. And there again is the pedestrian access to the out of the site as well. This was the previous scheme approved as a detailed scheme. It had this rather odd configuration, sort of circular configuration in the middle, and was clearly a less dense scheme than the one before us this evening. That was approved a year or so back. It doesn't make the best or most efficient use of the site. I think that probably the current scheme in terms of layout is certainly an improvement on that. But that's the previous scheme that's got approval already. Just looking at some of the details, a mix of materials are being proposed. These are details of the maisonettes. So again, the maisonettes themselves are kept at two-storey level, using a mix of brickwork. There's a sort of mottled brickwork detailing at each end of the buildings, which adds interest to it. These are the proposed bungalow designs, which will be located in the southwest of the site. Again, there's a mix of brick, render, and grey slate in terms of detail. And that theme is sort of carried throughout the rest of the detail. So again, you have a mix of render and brickwork. So not unattractive in terms of the proposed appearance. These are the corner groupings sort of which are located on the main access road through the site. So again, a mix of materials using boarding with brickwork. Again, other examples of the design. That's just the garage plan. I'll just go back to the main site plan. Just you'll have seen an update on your update sheet regarding surface water drainage. Additional details have now been submitted, and Essex County Council, SEDSIM, have now withdrawn their original objection and have recommended that there's no objection subject to an additional condition which requires that a detailed surface water drainage scheme for the site should be submitted and approved prior to commencement of development. I think members at the site visit this morning did raise a question about site density. So just for members' information, the existing Tokely Road development to the south, that was built in perhaps the mid-1990s. The density for that works out at 26 per hectare. The existing permission, that's the detailed consent I showed you a bit earlier, that was at 18 per hectare. And the current proposed scheme is at 25 per hectare. So there's some similarity between the proposed density and the existing density to the south. I think because there are obviously some maisonettes being included within the scheme, that does help to reduce the overall site density. So the proposed density is 25 to the hectare. A query has been also raised by members in terms of NHS contributions. They are still considering whether they want to ask for a contribution on this site. They've promised this within the next 7 days. So if we do receive a request for a contribution and members are minded to approve the application this evening, we will include that within the Section 106 agreement. I've mentioned removal of permitted development rights for the windows on the flank walls to the south elevations at the south of the site. There was a query over affordable housing numbers. It is 21 affordable housing units, although I think within your report it does refer to 24, but 21 is meets the policy level. Chairman, I think that's it. The recommendation is to approve the application. Thank you.
Thank you very much. Now we have ultimately 3 speakers here. Parish Councillor Paula Bland, is she here? If you'd like to come forward, Ms Bland, and I don't know whether you've been here before, but once you've got yourself settled and you push the microphone button down, you've got 3 minutes to convince us.
As a parish council, we acknowledge that planning permission has been granted on appeal by the Planning Inspectorate for a maximum of 49 units to be built on the land north of Tokely Road. This was despite objection from the tendering district council, the parish council and a number of residents. At the time of the original application, the proposed development was outside of the settlement development boundary in both adopted and emerging local plans. Tendering district council can now meet the land supply and housing criteria for the next 5 years without the need for an additional 18 units. The parish council objected to the original application on a number of grounds, and we are of the view that the majority of these grounds also apply to the current application. To summarise the objections, the site is not sustainable for 49 units and is even less so for 67. This is overdevelopment of the site. The facilities in the village consist of 1 public house and the Memorial Hall. There is no shop and employment is very limited. While there is a bus service that operates between Colchester and Clacton, the majority of residents travel by private vehicle for their own convenience, and we see no reason to believe that new residents will be of a different mindset. Reference is made to shopping facilities in Great Bentley and Elmstead Market, but these are limited and it is not easy to reach either village on foot. Of great concern for the parish council, and probably the greatest concern for the existing residents, is the increase in traffic that will be created while the site is being built and when it has been completed. It isn't unusual for there to be a minimum of 2 cars per household. The maths is simple in that the increase in traffic will be around a minimum of 134 additional car journeys through the estate each day, doubling if every car is used daily. The concern is mainly on safety grounds. While Tokely Road may be deemed on paper to be of a suitable width to accommodate this level of additional traffic, there are occasions when a site visit is valuable, which I understand took place today. From visiting the site, it is clear that there is a very sharp bend in Tokely Road that restricts visibility. Added to this is the number of vehicles that park on the road due to the lack of available off-road parking, often resulting in vehicles having to use the opposite side of the carriageway. This represents a danger to other road users and to pedestrians, especially children. Access onto the main road during peak times is difficult. This development will also have an impact on the surface water drainage and sewage disposal for the site and the surrounding properties, both of which have been the subject of great concern and correspondence between 2009 and 2015 involving the County Council, Anglian Water, Tendring District Council, the Parish Council and the community. It was extensively repaired in 2012, but there is still a need for tankers to regularly visit the pumping station, as it appears that the pumps cannot cope with the current volume at peak times. If the system fails, as it did prior to 2012, it could result in extensive flooding of sewage to the properties in Bromley Road. The Bromley Road residents, many of whom live in bungalows, are also concerned as to the impact that this development will have on their properties. The original plans have been revised so that 2-storey blocks of maisonettes with reduced garden length back onto their properties, which will impact their light and privacy. Thank you.
Thank you very much. Now the ward councillor is Councillor Fred Nichols.
Good evening, Chairman, members, officers. I speak purely as the ward councillor on this matter. You've heard what Mrs. Bland has stated, that the inspector said 49, and now we're confronted with 67. When the first application was put in, Frating Parish Council objected to overdevelopment, and to add an extra 18 houses is more than overdevelopment. It's absolutely ridiculous. I have some comments to make about the affordables, and can the officer show me where the affordable housing is going to be located?
Chairman, we don't actually have a plan for where the affordables are. I think they'll be placed within, throughout the site. So it's not a specific area at present.
Thank you. So they're not going to be the masonettes?
That's not to my knowledge, no.
Okay.
There'll be a mix within the site.
Okay, thank you. According to the report, the affordable housing is going to be a mixture of 1 and 2 bedroom houses. Well, there's a lot of people, if they need affordable housing, husband and wife, 2 children of a different sex, they need 3 bedrooms, not 2. So I draw that to your attention to start with, and suggest that if you're minded to approve this, that the developer goes away and comes up with a better mix for the affordable housing. Mrs. Bland also mentioned the sewerage problem, and I can confirm that a couple of years ago there were major problems in Bromley Road with the sewerage, and the chairman of Frating Parish Council and myself did a huge amount of work with Anglia Water to ensure that the drains were repaired and made suitable for the houses that were then present in Bromley Road, not an additional 67 houses. The problem appears to be that when there is heavy rain, the sewage system cannot cope, and it then goes to the pumping station, which then requires tankers to come and empty the pumping station. And I feel sure you'll all agree that this is not a very satisfactory method to dispose of sewage. And these additional houses will just continue to make the matters far worse than what they are now. And lastly, to the best of my knowledge, there are no masonettes anywhere in Frating, and these would be totally out of character with the village environment, the village setting, and the location of these masonettes. Thank you, Chairman.
Thank you very much. And finally, in public speaking, Mr. Marcus Nelson, who is the agent for the site. Welcome, sir, and once the button's down and you're settled, and you have 3 minutes.
Okay, good evening, and thank you for the opportunity to speak. I'll try and keep things brief, but just wanted to highlight the positive report your officers have provided as a result of their detailed assessment of the proposals. The report confirms the proposals retain much of the open space features on the previously approved scheme, and that the increase in units proposed is more in keeping with the residential density of the development around Tokely Road. The report also confirms plots and garden spaces are compliant with the current policy and meet the design requirements of the local and emerging plan policies. The case officer states that the scheme will not have an adverse effect on the trees around the site, and in fact the design has been modified to retain those trees. The scheme also includes planted buffer zones around the site boundaries that are to be planted with native species, and the extent of the open space proposed exceeds policy requirements. The report also confirms reasonable separation distances have been provided within the development and between proposed units and neighbouring properties, and concludes that sufficient consideration has been given to protecting the neighbouring residential environment. The case officer also confirms that Essex County Council Highways have determined the impact of the development on the surrounding highway network would be acceptable. We confirm the number of car parking spaces proposed for the scheme exceeds current policy requirements. Regarding some of the concerns raised by residents, we understand that the impact of construction traffic is a major issue, but that your officers have confirmed that a robust construction management plan can be conditioned to ensure the impact on Tokely Road residents is minimised. The client, Sanctuary Housing, have also confirmed that they will investigate alternative access arrangements, including routing from Bromley Road across the field to the north and through the industrial estate to the east. With respect to surface water, we understand that there's an amendment to tonight's proceedings that confirms acceptability, that a condition can be applied to an approval if it was such granted. And throughout the design development period, Sanctuary Housing and ourselves, we've been positively engaged with the council and the public. Before the application was submitted, the applicant attended parish council meetings and a public consultation event was held. In response to the opinions provided by local residents, positive changes were made to the scheme, including increasing distances between proposed plots and Tokely Road properties, increasing distances between proposed plots and neighbouring Bromley Road. In addition, planted buffer strip was added to the boundary that was not provided in the previously approved scheme, and 8 additional car parking spaces have been provided. Pre-application meetings were held with tendering planners, and we've also met with the case officer during the consultation period. Consultation was undertaken with Essex County Council Highways during the design development, and we've met and discussed the proposals with the designing out crime officer as well. As a result of these meetings and consultations, a number of positive changes have been made to the scheme. The proposals make good use of the site by providing much needed housing, and we therefore urge you to follow the recommendations of your officers and approve the scheme. Thank you very much.
Thank you very much. If you could knock the microphone off, it would be a help. Thank you very much. Turn to the officer now, see if there's any extra points that he wishes to add.
Yeah, Chairman, just to clarify, Councillor Nichols did refer to the flats and whether that'd be used for affordable housing. Yes, I can confirm they would be. So there's 8 units at the top of the site where I'm showing the cursor. They would be for affordable units, but clearly there would be a number of other units within the site which would also be for affordable units. But just to clarify, those flats would be for affordable purposes. Thank you.
Thank you very much. In which case, councillors, you've heard speakers on both sides. It's over to you. Councillor Everett.
Picking up the comment by both speakers about foul water issues potentially on the site, would the officer explain, please, what the Flood Authority have said in relation to that particular problem and whether that is going to be acceptable to deal with the issue?
Chairman, yes, the Flood Authority have withdrawn their objection to the scheme and are satisfied that the proposals will be acceptable. Just to perhaps provide a bit more information, in that particular part of the green, in the bottom left-hand corner, there will be an additional pumping station put in. And as far as I'm aware, the main there's another manhole connection at this point, which then leads through to the main road itself. So the main foul drain would go into the existing system. At the end of the day, the foul water system comes under the auspices of Angling Water. It's for them to ensure that the system works correctly. And certainly based on the current consultations that have been undertaken, both the Flood Authority and Angling Water are satisfied that the scheme can withstand this amount of development. Thank you.
Yes, come back.
Can I unpack that a little? My concern really comes from both of the speakers were mentioning, and particularly Councillor Nichols mentioned, that the problem appears to be with the foul water treatment when there is excessive rain. So that is a combination of foul water on the one hand and suds on the other. And however much this development uses a suds drainage system for the surface water, it sounds to me as though there's still going to be a problem for the foul water coming, extra foul water coming from this development, because of the likelihood of the rainwater in other areas, not on this development, creating a problem. So I question whether actually the two are joining up together appropriately to be able to deal with the problem.
Yeah, Chairman, I fully understand where the Council is coming from on that. I mean, the SUD scheme and the surface water scheme is as proposed, a completely separate system to the foul water scheme. Fully take on board the comments that have been made about foul drainage. Ultimately, it is down to Angling Water to resolve that issue. But if they would come back and say we can't cope with this development, then that would put us in a different position. That's not what they're saying. They're saying that it can accommodate the foul drainage. And I take the point. There is clearly an issue somewhere in the system, but it's for Angling Water to resolve that. Everyone pays their Angling Water bills for exactly that purpose. So it's for them to resolve that. It shouldn't preclude the development coming forward.
Thank you very much. Other councillors? Councillor Benison.
Thank you, Chairman. Page 21 at the bottom, one of the letters that's been received from the local community asks the question about the children's play area and what precautions are being made to, in respect of delivery vehicles to the site next to the children's play area.
Yeah, Chairman, there will be a construction management plan condition placed on the, if members are minded to approve, there would be a condition controlling that, the movement of vehicles within the site, and also the time, the times during the day when they'd be allowed to visit the site. So they certainly, it would certainly exclude weekends and holiday periods in terms of when deliveries would be made to the site. So that would be accounted for within that construction management scheme. I think that's something we would work with the applicants on, in ensuring that the scheme they put forward took that exactly that matter into account, because that's a number of issues have been raised about that. Thank you.
Yes, Councillor Baker.
Thank you, Chairman. Just make sure I'm in the right place. On page 21, the Tree and Landscape Officer has made a comment in the second paragraph of his response. This document has not been attached and is required prior to the determination of the application. As regard to a tree protection plan. I just wonder if you could comment on that, please. I do have another question as well.
Yeah, Chairman, I think we would pick that up with a condition and ensure that detail is submitted. We can certainly, ask for that.
Thank you.
Thank you for that. And the housing consultation, I mean, Councillor Nichols mentioned that with regard to the numbering and what there is, and there are no masonettes. I noticed that it just says 30% affordable housing agreed. Well, that's policy. But what I don't see in this report is what the demand is for what sort of housing within the area, which I would expect from our housing department, to say sort of what we're short of, particularly. And if, from what Councillor Nichols was saying, maybe 3 bedrooms are required. I know in my ward everything's required, but I just wonder if we can have a comment on that, please.
Yeah, Chairman, actually I've got the response from the housing officer here, and I'll read that out to you. This applicant is a registered provider, and they're going to deliver a number of market and affordable homes. We have agreed with them the number of affordable homes and the tenure mix they will deliver as stated on their application. So that has been agreed with the housing officer.
Thank you.
Good. Further points? Anybody? No further points? In which case, do I have a proposition from somebody? Looking all very quiet. Yes, Councillor Benison.
Thank you, Mr. Chairman. Is it possible to see the, I mean, we've got this plan. Can we look at the previous one that was approved?
The detailed?
Yes, the layout like that, yes. Yeah. And did that include any maisonettes on that one?
I can't recall off the top of my head, Chairman, sorry. But that certainly was the layout, and it's clearly a much less dense development.
Having looked at the new plan, I know we're very concerned that there are more units on there, but I think the layout is so much better. I think more thought has been given to it, and notwithstanding the fact that there are more units on there, we do have affordable housing for youngsters leaving home, wanting to stay in a village. I think the layout is much better, and I don't see any problems with it, and I would therefore like to propose that we accept this application.
All right. Further speakers? Do I get a seconder for that, please? At this stage, yes, I do have a seconder for it. Councillor Fowler. Do you wish to add anything, Councillor Fowler?
Thank you, Chairman. I do agree with my colleague, Councillor Benison, that the layout overall does appear to be better than the previous one, and of course the affordable housing as well. So I'm happy to second Councillor Benison's proposal. Thank you, Chairman.
Any further points before I put it to the vote? Yes, Councillor Baker. Oh, Councillor Alexander, sorry.
I'm still deeply concerned by this surface water and sewage. It's something that was said my ward in particular suffers the same fate, that every so often huge amount of tankers have to arrive to pump out the sewage from the bottom of Cherry Tree Avenue. And I know the implication that creates and disruption and what it causes throughout the entire ward itself. I'm not happy with that statement made by the ward councillor, and I believe that his concern, I share that concern, and I'm just wondering what could be done by the developers to address that along with Anglo Water. I know you're going to say it's their problem, and they're actually stating that the pumping station is adequate. But if it was that adequate, why do they want all those tankers to move in and pump out at certain times excess sewage water?
Yes, I could ask Mr. Norsefield.
Yeah, Chairman, I think, again, the actual detail for this will be secured by condition. I think we'd take on board what the council is saying in this instance and have those, ensure that, a robust system is put in place. I think we can certainly raise that with Anglian Water and ensure that that's, through the applicant, that situation is resolved.
Right. Now, I've got a proposer and a second. Yes, Councillor McWilliams.
I just wanted to add to what Councillor Alexander was saying. I know exactly what it is like there, being the neighbouring council, as well as the problems that they actually experience in that area. And I'm pleased to hear that what you're saying, and I hope it will follow through, that if we do agree to the application this evening, that there is something more, stronger than what there is at the moment to help with that situation, because it's not a good one, and it does reflect on neighbouring villages as well. I just want to make that point.
Right, Councillor Everett.
Thank you. And in light of all of those comments, may I suggest an amendment to the proposal, and that amendment should be that development shall not begin until drainage works have been carried out in accordance with details to be submitted to and approved in writing by the local planning authority as a condition on the application.
Chairman, just to confirm, that condition would be on any permission given.
Yeah, Councillor Baker.
Thank you, Chairman. I'm in agreement with Councillor Benison and Councillor Fowler's proposal, and I just suggest that we add a bit into the conditions or into the recommendation with regard to NHS contribution, because it's not there at the moment, and they have agreed to come back. And in the previous application, they had made a request for funding. So just make sure it's in there. Thank you.
Right. I'm going to take a vote now. So you know you're voting on approval with the conditions that are shown on page 15, plus the extra bit. 14 does cover foul water strategy, but plus the additional items that we've just been talking about, and to note that there's no, at the present moment, any NHS contribution. So you know what you're voting for. Those in favour, please show. And those against, please show. And one abstention. So that is approved with those conditions. Thank you very much. We now move to A2 on the agenda. It's planning application 1701909. This is an outline application on that rather delightful site that we saw this morning in the bright sunshine at Greenfield Farm, Harwich. And I think it's Mr. North on this one.
Chairman, thank you. This is, as you said, outline application for the erection of 42 dwellings, with all matters reserved except for access. So access is the key thing that we're looking at today, including the principle of the development. It's located at Greenfield Farm, Main Road, Harwich. Again, you'll be familiar with the site, having had the site visit this morning. As you'll note, the main access into the site comes from what's known as Main Road via a slip road onto the Green, which is a relatively minor road, which predominantly serves to the west the existing residential development or frontage development, and then to the east you've obviously got the Dovercourt Cemetery and other developments further to the east. So that will form the main access into the site. You'll also be aware that the existing property owned by the applicant will be demolished to make way for the main access into the site. You'll also be aware of a number of existing buildings on the site. It's a former agricultural or horticultural site, and I believe there's a history of it being used as a farm shop in the past as well. You have an existing pond with a number of mature trees around the site. That will form part of the attenuation scheme to what's being proposed, and as you're aware, the A120 is further to the north. So again, the aerial gives a bit more context to the site. As we'll see from the photographs in a minute, the site does slope relatively steeply away from the existing residential properties to the south. But as you can see, the existing pond to the north, and there's the A120 even further to the north. In terms of the emerging local plan, it is allocated as a housing allocation at present. And you can see the red shaded area is the current application site. You'll have noted in your report that Highways have made it very clear they wouldn't want anything in addition to 42 dwellings being served from this site, and I think certainly as officers we would fully agree with that. I think additional access to the site would have to come from the A120 or via what is a large mixed-use application further to the west, but that's for another time. But as noted, it's an allocation in the emerging plan at present. This is the existing site access looking across the Green. So that's the house that will be removed as part of the development. As you can see, or you'll have noted this morning, there's a range of different dwelling types within the existing frontage development. That's the access road leading from the main road onto the Green. That's the house to be demolished. This is just looking into the site as you move through the site itself. As noted, there's a number of poorly kept buildings on the site at present. So this is looking north along the existing access or the proposed access point. This is looking back at the access point. And another view of that as well. And just moving through the site, slightly untidy at the moment, I think, to say the least, but obviously those buildings will be cleared as and when the site's developed. This is looking further into the site, so again there's another building within the site. This probably shows quite clearly the quite steep slope, which, as the land slopes away from the existing development, I think that probably lessens the impact on the existing development to the north as well. I think that does show that the slope is quite steep at this point. That's simply a further image of that. I think this photo in particular shows the way the slope does slope quite steeply away. That's the existing pond, and again you'll note there's a number of mature trees and bushes around the site at the moment. They'll be retained as part of the scheme, as will the pond, which will be a major part of the surface water drainage system. And that's just looking down to the south of the site towards the A120. As noted, it's an outline application, so what you have before you tonight is, for detail, is purely the site access. The remainder of the detail is purely indicative at present. You can see the type of layout that's being proposed, and I think the nature of the site would probably dictate this is how the site would be developed. You have the main road going through the site itself, with a couple of spur roads or feeder roads coming off that. You'll note, in terms of existing dwellings, there's a good depth of spacing between existing dwellings and the proposed site location of the new dwellings. In terms of amenity, there'd be no loss of amenity to existing dwellings. This particular property here is actually indicated to be a bungalow, albeit it is outlined at present. Again, that makes sense. It's in close proximity to the rear boundary of the existing property to the south. I think it makes sense that that's retained as a bungalow. And I think if members approve this application, certainly at reserved matter stage, would expect a bungalow, I think, to be cited in that position. The applicant, however, has submitted some indicative amenity space plan just to show how the amenity space would play out. Again, the proposed amenity areas meet all the requirements in terms of policy, and certainly provide reasonably adequate amenity space for the various units. That's just showing where the indicative parking would be. There's certainly space on the site for each property to have its own garage, and it can more than meet the parking standards for a scheme of this size. You'll note actually to the north of the site, next to the pond, the applicant, I believe, does intend to build another property there for themselves. So that's a replacement dwelling really for the property that will be demolished. This is the surface water attenuation scheme. Again, you'll see clearly, because the land slopes to the north, that clearly is where the water will go. The existing pond will be used as part of that, with an overflow into a further attenuation pond sited further to the north and closer to the A120. That's all within the applicant's land ownership, so that's not a problem in terms of providing that. And so this is the detail in terms of the proposed road access. Obviously, at present, we have a single, or the road comes into a point where it then joins a slightly smaller road which serves the existing properties to the west. At that point, a new junction will then will in fact be formed with a widening of the access road into the main site itself. So that's been approved by the Highway Authority. They're satisfied that the proposed access can cope with the traffic proposed, as well as the traffic entering onto the green and then onto the main road itself. Again, the applicants provided some indication of what the proposed dwellings would look like. Again, it's a mix of brick, slate, render, although at this stage, clearly, this is a reserved matter, so we may get something different at a reserved matter stage, but I think it gives an indication of the type of dwellings we can expect. Just some indicative sketch plans, which I think are quite useful. I think this one, particularly to the bottom right-hand corner, shows the relationship between existing development to the south and how the new development would fit in. This is the main site access. So as you come into the site, again, you'll be met by the flag wall of a bungalow to the left-hand side, and then housing to the right. And again, it just gives an example of the type of dwellings that could be located within the site. So I think it could be a scheme that, you know, we'd expect to be designed to a high standard. I think there's no reason why that can't be done. Chairman, that's it. The recommendation is for approval. Thank you.
Thank you very much. On the public speaking front, all we have is the agent, Mr. Michael Aronson. Welcome, sir. Once you've got your microphone live, which I can see it is, you've got 3 minutes, and once you're settled, sir.
Thank you. Good evening, members. We have the outline application for the development of 42 dwellings at Greenfield's farm, as set out on this agenda tonight. The application has been referred to committee because the site's outside the defined settlement limit shown in your 2007 local plan proposals map. The 2017 submission draft local plan identifies the site as part of an allocation of 164 homes in total, along with the adjacent fields to the north. To date, the emerging local plan has carried weight by virtue of the progress made on the plan, and given that the borough's 2007 housing policies are considered to be out of date pending the adoption of a new local plan, I understand from officers that despite the recent setback to the plan, the proposed housing allocation sites such as this site retain their weight in planning decisions. With all this in mind, we emphasise that although not an adopted site for housing, a thorough process initially led by tendering district council has taken place over considerable time, and as such, Greenfield's farm is a planned housing site and it's not a windfall housing site. We have engaged with planning officers in a constructive way from the outset, and we present an application that fully addresses every relevant planning matter: transport, noise, flood risk, drainage, ecology, landscape and visual impact, and impact on trees have all been assessed in detail by specialist consultants who have engaged, where necessary, with statutory bodies. As a result, we have a scheme that, subject to potential conditions and obligations, is considered very sustainable by officers. One of the main issues raised in residents' comments is the proposed means of access and the potential impact on the village green. I emphasise that the access arrangements have been designed in consultation with Essex Highway Services. Two key aspects of the proposals are that, firstly, the village green will be protected in its entirety, and secondly, it is agreed that there would be no need for a mini roundabout that was first planned at the outset. We initially submitted the application for 49 dwellings, which has since been reduced to 42. One of the benefits of this will be that there will be more open spaces within the site, again addressing comments received early on in the application period. The applicant has negotiated with tendering in relation to Section 106 obligations and conditions, all of which are accepted. The members will be aware that this site is an opportunity to deliver a high-quality housing scheme in the borough, and I trust you can support the officer recommendation.
Thank you very much, sir. Nothing further to add on that, Graham, at all?
No, Chairman. I think we've covered things.
Let me start the questioning going. I thought probably one of the most impressive trees that we saw this morning was, my understanding, the white willow, which I don't know whether you could get the tree plan up. It's indicated as T5, and the officer is saying further examination says there is extensive decay in it. I must admit, we didn't crawl over the tree, but it is a very impressive looking tree at the present moment. Have you got a tree plan? Are we talking about the same T5 that I'm thinking of?
Chairman, whereabouts was the tree, was it?
As you drive in, it's sharply on your right-hand side, so somewhere there abutting the cemetery.
Right, okay.
A little bit further in than that, I would have thought, yes. Yes. That's why it's T5 that I'm... Could be that I'm talking at a different tree. I don't know. Colleagues, whilst we're searching for that, the next points that you would like to pick up? Yes, Councillor Everett and then Councillor Alexander.
Thank you. Picking up actually on the very point that you just made and taking it a step further. Decay in trees of that sort often gives the opportunity for roosting bats. And I'm concerned generally with the whole of this site treatment because of the effect on potential effects on ecology. While obviously the issue that you refer to might relate to bats, what I'm more specifically looking at is the issue of dormice. Now, dormice are a European protected species, and because of that, benefit from very specific legal guidance on how they should be dealt with in planning applications. I would normally expect in an outline permission to see obviously a Phase 1 survey, which has been done, but this Phase 1 survey picks up the issue of a number of species, including dormice, and then jumps suddenly to mitigation. Well, actually under the law, you can't jump suddenly to mitigation. You actually have to do the presence surveys for the individual species referred to make sure that they are on site and what sort of ground they are covering. So I'm a bit concerned that we haven't got that information in front of us. Now, I have no doubt that we could, if we were so minded, and in fact it is in the list of conditions, require conditions to deal with that. However, I would make the point to all of the councillors here tonight that actually we are taking a decision on the outline itself, which is in principle, and strictly speaking, that information should be before us before we make any decision on the principle of this application. Sorry, that was a long diatribe, but it's something I wish to get off my chest. Right. Councillor Alexander.
Thank you, Chair. By now, colleagues, you'll realise I do have somewhat of an interest in trees, and I did go and look at this willow. It was a magnificent salix, this is by statement, but it is suffering from deterioration. Salix, especially goat and creek, do not enjoy the same longevity as an oak, for example, or a beech. They have a much shorter lifespan, and maybe this one has come to the end of its time. I go with my colleague on the bat roosting thing, and I do not wish to challenge his vast knowledge on that. But the thing that's bothering me about the application here is on page 40 under education. And I bring your, if I may, Chair, to bring your attention to the bottom paragraph of development sits within the priority admissions. And if one would, I presume you've all read through that, and I'm a little concerned of how you're going to address the educational background to this when there is insufficient places in the school already, and to go on into the secondary schooling it is quite concerning. I'm sure that could also be addressed, and I'm wondering if the officer would like to enlighten us on that.
Chairman, clearly there are financial contributions required from the developer, so that will actually be used to mitigate those particular issues. I'm quite satisfied, the education team will have looked at that and taken exactly those points into account. So I think there will be mitigation provided for that.
May I return to Chair?
Yes, I was just going to see whether the officer's got any of the other answers.
I think in terms of the tree, Chairman, I think it's just looking at the indicative layout, it's probably that central area just there. That's roughly where the tree is. Now, one thing we could do, obviously, in further discussions in terms of the reserved matters detail, is at that time look to see whether the tree is actually capable of being retained. Now, clearly if it is, we could work with the developer to look at a slightly different layout to accommodate the tree. That's possible. So if members felt that was a key element, then we could certainly work with the developer to try and achieve that. But clearly, if it's decayed and dying, then it's not going to be there. But there's no reason at all within a future landscape plan that there will be additional tree planting as part of that. So yes. If the tree is at the end of its life, then we can certainly look to ensure that the replacements are provided.
Right. And Councillor Everett, are you waiting for any answer on your question of...
Yes, I think it would be helpful if officers would guide us on how they see the issue over us taking a decision without the information before us regarding specific species on site.
Chairman, I think actually at paragraph 635, the officers have referred to the fact that specific site surveys were undertaken by the applicant. So I think they have actually addressed perhaps that issue. And as you noted, there will be a condition requiring further information to be supplied as well. So there is certainly that survey work has been undertaken, it appears.
Right, now I've got Councillor Bennison, I think, and then Councillor McWilliams.
Thank you. On the picture we have up at the moment, the slide we have up at the moment, you spoke about the bungalow at the site access, but opposite we have, at the back of number 660, we have a house. On another plan you've shown us, the site entrance plan, it actually shows a bungalow opposite that bungalow on the left, I believe. Yes. At the back of 660, that looks like a bungalow. At the rear of 660 as well.
Let me just check this. Yeah, it is different too.
Yeah. I mean, if we're having a bungalow on the left, surely it would make sense to have a bungalow on the right at the site entrance as well, as in that plan. Yeah, but I mean, you did say that you would like to make sure that there was a bungalow on the left there. Would there be any cause for having a bungalow on the right as well?
Chairman, there's no reason at all. We can't ask for that. If members feel that would be a better appearance, an entrance to the site, then that's fine. When we do have, so I think 660, as you said, it's a two-storey dwelling, so I suppose there'll be some continuity in having a two-storey dwelling behind it. But saying that, there's no reason at all why it couldn't be a bungalow as well. So again, we can, if members feel that's important, we can discuss that with the applicants for the reserved matters, certainly.
Yeah.
It was just that Graham had mentioned that it would be important to have that bungalow, and that we ought to stress that there should be a bungalow on the left. So that was the reason.
Good. Councillor McWilliams.
Thank you, Chairman. When we were down there this morning, obviously the agents were there, and they were quite adamant that the trees weren't going to be interfered with unless they had to be. And it actually is a lovely site. I did quite enjoy myself down there, I have to say, like a few of us did. I obviously am aware that we actually should be looking at the access. That's what we're deciding on now. And everything else will come back to us under reserved matters that we can actually make comment about. And I believe that's when we get the ecology reports and everything else that is related to all the other questions that we've actually asked. I'm happy with that access, and therefore I would like to recommend approval. Thank you, Chairman.
Right. And I have a seconder there as well, but I've also got Councillor Alexander as indicated he wants to come back.
Oh, I wanted to come back on that, if I may. Thank you, Chair. I'm not quite satisfied with the reply to the question about primary education. 42 spaces will be required, not at secondary level, because at secondary level seems to be able to cope with any influx, but it's the lower level, as indeed with all schools throughout Tendring and indeed Essex, where there is a huge demand for up-and-coming youngsters with very little spacing. They're already close to capacity, and knowing the schooling as I do down there, I'm wondering how we can justify 42 spaces where it's so close to capacity, and 9 will fill it beyond that, and there will be no others. So the only place you could go is maybe to Colchester, or maybe Manningtree would be able to take some. That's my point, and that's what I wanted you to just enlighten me on.
Chairman, I think what the situation is, that this development, as it says at the very bottom of page 40, it would add to that need. It doesn't mean that it would generate all the need for that contribution. So the way the county have then based it that on these additional 42 dwellings, the contribution amount would be 187,190, but they accept that other developments would also generate towards that need as well. So this particular site wouldn't generate all the need. I think that's what they're trying to say. Yeah, that makes sense. Yeah.
So, Councillor Everett.
Back to the ecology concerns I had. Thank you for your response, and I fully accept that I hadn't read the report correctly, and I see the nuance in there that tells me what you've just said. And to a certain extent, that actually allays a lot of my fears. But I would like to just make sure, for my own presence of mind, that we have sufficient in terms of conditions to make sure that when this comes back to us for reserved matters, that we do have everything in front of us that we need. This mentions an outline mitigation strategy. It would need to be more than an outline mitigation strategy at reserved matters to really satisfy me. So thanks for what you said. Fully accept that I was in the wrong there. And if we can make sure that that's okay for reserved matters, then that would be brilliant. Thank you.
Yeah, Chairman, as I know, it will be secured by condition, and we'd definitely make sure that that's reflected in those reports. Absolutely.
Thank you. Councillor Fowler next.
Thank you, Chairman. Could I just have another look at the slide with where I think the roundabout was on? That one. Yeah, that's the one. Yeah. Okay.
That's a tree.
Oh, right. It's the wrong one. Wrong slide. Where was the roundabout going to be? Oh, it's not. It's gone.
It's been dropped.
Right. Okay. That's been dropped completely. Further up, which is not on that slide, where the entrance to the Dovercourt Cemetery is.
Yep.
That is where the traffic will go out onto the main road from that.
Yeah, that's correct. At least,
I mean, I do have concerns about that. Highways obviously do not have concerns, but I do, as a local resident who knows that area very well. That's why I have concerns, and it's my personal view, but I just thought I'd let you know that I have concerns about that. I do, because that area there is often quite congested, and it's also difficult to get out of that road because of traffic that parks along that road. I know because I go in there quite often. So that's how I know, but that is my personal opinion, and obviously the highways officers don't agree with me, so I just thought I'd mention it. Thank you, Chairman.
Right. Councillor Benison, and then I'll take the vote, I think. Councillor Benison.
Thank you, Chairman. It was just something I picked up earlier. There was mention of the village green and the impact it might have on the village green. Can you tell me whereabouts the village green is, please?
Right. It's this piece.
yeah, that is it. That is known as, yeah.
And the other side.
I mean, the road itself, confusingly, is also known as the Green. So, yeah.
Right. That being the case, I'm going to take the vote. Now we have a proposer and a seconder lined up. Good. And it will be, the vote is on approval, including the conditions in particular that are outlined at the top of page 31. The first one, probably the most important one, that it comes back under reserved matters. For everything else, so all the buildings that we've seen on there tonight were indicative only. We're talking really purely and simply about the entranceway. So those in favour, please show. That is unanimous. Thank you. That is approved. Now we come to item 3, which is a site which we know exceptionally well, I think, and it's application number 1800861, and this is a detail, and it's land east of Tye Road, Elmstead.
Right, thank you, Chairman. So this application is a resubmission of a previous reserved matter application for access following the grant of outline planning permission appeal for 32 dwellings. So as the Chairman mentioned, members are aware of this site and previously approved previous application in February earlier this year. So the application does not seek to change the details of the proposal, but the wording of condition 2. So currently, condition 2 requires the footpath along Tye Road to be provided before development commences. And this application seeks to amend the condition so that the footpath is to be provided prior to first occupation. So as it's a revised application, I will remind members of the scheme, but as I said, it remains the same as previously approved. So the site is this area. Here it's currently an arable field. Tye Road is in this location and Colchester Road is along there, and this area of land has outline permission for residential development as well. So these show some photographs of the site. Probably most importantly is the view of Tye Road. So the footpath is proposed along the western side along this area here. That is what was approved at shown at outline stage when the appeal was granted, so that was indicative. And this application shows all the proposed changes, so I have split them to make them clearer. But effectively, you've got the vehicular access onto the site from Tye Road, a pedestrian access onto the site from Tye Road, and the footpath along Tye Road and works to the junction, and also a potential access into the area that's got outline permission onto the adjacent site. So this shows it in slightly more detail. So it's a junction with Colchester Road, the pedestrian access, the vehicular access, and the footpath along this location here. Again, this remains as previously approved, but that shows the junction. So vehicular junction with footpath either side. And that shows the pedestrian access within the site, so that will link presumably to a footpath within the site to allow pedestrians out of the development and onto the proposed footpath. And that shows in more detail the proposed footpath. and that shows the junction work, so the footpath will link to the existing footpath running into the village. So if I move back into the general plan, so as set out in the report, the details of the proposal remain the same, and the MTPF sets out 6 tests for planning conditions to be considered reasonable. And these are that they must be necessary, relevant to planning, relevant to the development, enforceable, precise and reasonable. So it's officers' view that whilst the proposed or the condition that's been imposed, which requires the footpath to be carried out prior to development, meets some of those tests, that actually it's not a reasonable condition to impose, as until the properties are occupied, there is no pedestrians that are generated to use a footpath. And therefore officers recommend approval of the application.
Right, thank you very much. Parish Councillor Mike Kirby, is he here? Yes, welcome. Come forward, sir. And once you've got your mic live, which you have, you've got 3 minutes to address us.
Thank you. You say you're familiar with this. I'm here on behalf of Elmstead Parish Council to say that we would ask that you do not reverse the original decision and the footway is provided before any building work takes place. And I know that some of you came and had a look for yourselves this morning. The Tie Road itself joins at the one end the A133 and goes through beyond, and was itself widened a while ago when further along Tie Road is Allen's Farm. And when they were given permission to build a reservoir, the Highways Authority widened Tie Road so that the HGV traffic could pass with safety. Allen's Farm now have approval to build a second reservoir, and so that vehicular traffic will continue, and Tie Road is quite a busy road with heavy vehicles. The development that has been approved is, although if you look at the site, on the one hand linked to the village, it is actually completely separate, and the only way in and out of that development is down Tie Road. So Highways have widened the road, and yet we're told they're going to provide a 1.5 metre footway. The owner of the fields to the west and the east of Tie Road is adamant that it cannot be built, and has taken legal advice from a QC who says he does indeed own the hedges and the verges either side of Tie Road. And because we believe the footway is crucial, we would ask that the original condition that the footway be put in to everybody's satisfaction before the building work commences. Thank you.
Thank you very much. And now the ward councillor, Councillor Fred Nichols.
Thank you, Chairman, members, officers. I speak purely as the ward member on this application. And I state the previous decision made by yourselves is the correct decision. The planning inspector opted out of making such a decision on the pavement and access and left it to you. I can confirm that I have received an email from the owner of the land on either side of Tie Road, and if you'd permit me, I'd like to read it. Thank you. I can confirm I've taken Council's opinion on this matter from Stephen Sylvain, QC, who is acknowledged as preeminent in highways matters. His opinion is that I do indeed own the hedges on both sides of Tye Road. He also advises that there is a strong case for arguing that the highway only extends to the bottom of the mound, i.e. the high grass bank between the western hedge and the tarmac is not highway and is probably owned by us. My solicitors have already written to Highways pointing this out, but will be reconfirming shortly. As I've said before, I do not understand why Hills are so keen to change the timing of the footpath installation unless they think they can avoid doing it. Kind regards, and the owner of the land. The decision before you is very basic. Is there room for a 1.5 wide pavement without interfering with the hedge? If not, you do not have an option. A large number of ramblers and walkers at this time of the year use this road. I am aware of the amount of increased traffic that are coming out of Clacton and avoiding Clingo Hill by cutting through this road through to Crockerford. So therefore, it is necessary to have a proper pavement of the required width along this road, and you should not be looking at ways to avoid it. And I believe that until all agreement has been made by all parties, this footpath should be provided. Whether it's going to be provided before the development, after the development, the crux of the matter is the footpath, or the pavement, whichever you wish to call it, and there is not room to provide it. And you've all been there, you've all seen it, you've measured it. So I do ask that you return to your original decision and ensure that that is what you agree with. Thank you, Chairman.
Thank you very much. I'm going to ask Suzanne whether she wishes to add anything at this stage.
So just to clarify to members, the proposal is to continue provision of the footpath. There's no question at this stage that the footpath not be provided, and that is clearly in the condition and considered to be a reasonable aspect of the development and a reasonable requirement. The question that you're asked to be considered in front of you this evening is in relation to the timing of that provision. Members will recall there was a lengthy debate when it previously went to committee, and it was members' recommendation that it be provided prior to commencement of development. And I understand those reasons why, in terms of that they had queries about the whether it could actually be provided. The amendment is to provide that prior to first occupation. So it will still be provided, and if for whatever reason it can't be provided, then the houses ultimately can't be occupied, and it's for the developer to do that due diligence to ensure that all his conditions can be met before he commences development, or they do so at their own risk. In terms of the point that people actually use the Tye Road, yes, you see at the visits that there are pedestrians that use that Tye Road and obviously would benefit from the footpath. But I'll just point you to paragraph 6.11 of the report that states that conditions cannot be proposed to remedy a pre-existing issue. So you can only look at what the development creates, not to use this development as a purpose to remedy an existing issue. Thank you.
All right, councillors, I'm going to ask for some comments, but I'll start by 2 Peneth if I can get mine in unusually at the front end. The way I'm viewing this at the present moment is exactly as the officer said. We're talking about the development and the effect that it would have. Now, we already know that there should be a footpath there, whether the development went ahead. My fears are that if the development went ahead without the footpath, you'll have not only the traffic going up to the two reservoirs, you'll have the traffic going up to the biodiversity, I'm not sure quite, the generation plant. That's going up whether we like it or not. What I don't want to see is the construction traffic for this building site going up there as well. And that, I think, is my personal reason why I think we should get the footpath in early. Said my say now, colleagues. Yes, Councillor Everett.
Can I make a request, please? Can you show up on the screen the drawing number S161/216 revision C?
That one.
That one, lovely. Yeah, I'm sure it is. Thanks. This diagram, plan, whatever you want to call it, doesn't only look at the issues relating to the footpath. It also looks at the access onto the site, both for construction traffic when it is being constructed and for subsequently the access for people using the new site. So, as far as I can see in the report, the only thing that is mentioned is about the footpath along the road. Yet actually, the condition refers to more than that. Can you please, as officers, explain what your position is relating to that condition and how it affects the access to the site, both for construction traffic and indeed for final use by people when on the development?
Yeah, sorry, Chair. Just to confirm that issue, the condition refers to the footpath and highway works as shown. So it refers to all the elements of the highway works shown on that, and that is what is proposed under the revised condition. So we are talking about all the works on that plan.
Thank you. That's useful clarification. If we're looking at all of the works, not just the piece that, albeit that it is very, very important, are we talking about something that really this condition goes to the heart of the planning permission? And if that is the case, and it does go to the heart of the planning permission, would we be in a position where if this condition couldn't be satisfied, that the whole permission would fall?
While the officers are searching through that, my first thoughts were the outline was granted by an inspector. But does your question mean, is that one likely, could we overturn the inspector's decision effectively on outline?
No, it isn't so much that. It's about how one can introduce Grampian conditions and under what position they are appropriately used. I mean, to move on from that, when you answer that, that might be helpful. To move on from that, the NPPF is quite clear about conditions being used when the land is not in the ownership of the applicant. And this is directly relevant to what we've been told this evening. And I'll read from the NPPF. When can conditions be used relating to land not in the control of the applicant? Conditions requiring works on land that is not controlled by the applicant or that requires the consent or authorisation of another person or body often fail the tests of reasonableness and enforceability. It may be possible to achieve a similar result using a condition worded in a negative form, a Grampian condition, i.e. prohibiting development authorised by the Planning Permission or other aspects linked to the Planning Permission, e.g. occupation of the premises, until a specified action has been taken, such as the provision of supporting infrastructure. Such conditions should not be used where there are no prospects at all of the action in question being performed within the time limit imposed by the permission. Where the land or specified action in question is within the control of the local authority determining the application, for example, as highway authority where supporting infrastructure is required, the authority should be able to present clear evidence that this test will be met before the condition is imposed. Well, that second bit isn't the case, it's the first. There are a whole load of judgments in the High Court on this very issue. And I think, and I take the advice of the solicitor, I think we need to be clear about why it is that we think that this condition is so central to the Planning Permission, because that is what makes it legal or not in High Court terms. There is other guidance, also actually in the letter from the applicant. It says such conditions should only be used where the local planning authority is satisfied of the requirements of the condition, including the timing of compliance, are so fundamental to the development permitted that it would have been otherwise necessary to refuse the whole permission. So that rather indicates to me that actually what we are trying to do here is actually reasonable. May not fit in nice, easy tick box terms, but it is actually reasonable because we have thought of that.
Right. Councillor Alexander.
Thank you, Chair. In respect of the statement made by yourself, sort of like returning the decisions made by the inspector themselves, we heard from the ward councillor that the inspector failed to make a decision upon that. Therefore, if there's no decision been made, how is it possible that we can reject his decision in the first place? The second thing is that we hear that once the properties have been built, and I have got to be blunt on this, I do not dislike this application. I think the houses, etc., would fit quite nicely. The fly in the ointment here is what we're talking about right now, and the reasonability to that challenge. So, with that in mind, we hear that until the first occupants move into those properties, then the responsibility of building that. Well, I do not quite understand, if they wish to get this built, why they can't build it first, if they've got to build it last. It certainly doesn't make any sense to me. No logic whatsoever. Now, I've had this myself in building my own properties. You have to abide by what is said and told to you. And I don't think that we are being unreasonable. It's before us, and therefore we become the voice of reason within the reason laid out. And we think that that road is dangerous. The local police authority will tell you that road is dangerous, because I asked them. We were told when we got there today, get off the road quick, it's a dangerous road. So therefore, we need to have some kind of protection in place for those people who would be walking down there. And I travel that road a lot, and I have never seen a pedestrian on that road in my life.
Councillor Holmes.
Yeah. It's been said already that a lot of people use that road already without the footpath. So the reason it's going to be put in is for the occupation of the houses. It's only going a short way down the road. Do the builders have an ulterior motive? Do they know that they can't build what they want to build as far as that goes? And are asking now. And if we agree to this, are we saying that the inspector, did the inspector allow the appeal, right, on this process? Or are we going against the inspector if we say we want it done, well, with the inspector, when we say we want it done before? If we go against him, is there a precedent set anywhere? I don't know. I mean, he obviously agreed the appeal on this process, exactly this. And I haven't read the appeal completely, but it was approved, allowed that they have the appeal on what we see here. So why are we even discussing it? Because I didn't think we could go against the inspector.
I don't have the appeal decision, although I have read it. My recollection was the inspector approved the development of the land and then said, and you'll have to effectively sort out the footpath arguments yourselves. He didn't make the decision, he sidestepped, but that's my recollection of it. Councillor Alexander then?
Well, that's the whole point of what I was saying. We're not going against the inspector or anything that the inspector said, because the inspector has not made a decision. And at this moment in time, we are, as far as I can see, trying to see the reasonable way forward. If we allow the first buildings to be built, and then that's the path, I reiterate what I said earlier. They will have to build it in order for the people to domicile those properties. That was what was said here tonight and recorded. So, what is the difference between building at one end or the other? I can't understand. Or are we looking, the fact is that they might be built with people inside of them, and then we'll have a long, arduous task and legal wrangle of why they won't build it. And is this something that we'll be looking at? I know there's 11 houses along that road, some of them as much as 2 or 3 miles away from the entrance. So where the pedestrians are all coming from in their hordes, I'm not too sure. But we are looking at the houses that are going to be built there now and the people who will walk with prams and babies or whatever, carrier bags, down the road, which they've been told, no, you can't build on. Now, what position does it leave us as elected members to make such a decision within the bounds of being reasonable?
It's, Councillor Benison next.
Thank you, Chairman. We've heard this evening from one of the speakers that the land on either side is owned by the same person, and that their ownership goes up to the road. So which bit does Highways own where they are proposing to build the path? Do Highways actually own any of it? Because it seems tonight as though we might be getting ourselves into hot water if we say yes to this. They then build the houses and then find that they cannot build the path because the land where the path is proposed is not in the ownership of the Highways Department. So we would then have houses built, there'd be a fait accompli, and there'd be no footpath. Also, anyone who wants to go and view these houses once they're built with no footpath, anyone from the village would not be able to walk up that road because there's no footpath. So how would they go and view the houses? They would have to take a car up there and park along that road, presumably, because nothing would be built there apart from one house, allegedly.
Yeah, my fears are the construction traffic in between. Councillor Brown's indicated.
Thank you, Chair. My opinion is that whether you build the footpath first or last, before I think we should vote on it, it should be absolutely cast in stone, whether legally or practically. Simple as that.
Right, Councillor Everett.
And to pick up on both those points, I think one of the other things that, if you could argue that the path wasn't necessary before occupation of the houses, you could certainly argue that the access is, at least to base core level. And so therefore, actually, in terms of rationale for the wording that we originally used, that I believe in itself is reason why it has to be done before the development commences.
Thank you. Councillor McWilliams.
Thank you, Chairman. I'm just wondering, obviously councillors have... sorry, did that the last time. Members, not members, the officers. It's all right, I just need waking up. Officers have been having a little chat, and I would be rather interested in what they're actually feeling and thinking at this stage as well, please.
Suzanne, are you going to take it?
Yeah, so in terms to try and address some of the issues that have been raised, I think in terms of ownership, this was an issue that was discussed at length previous time. The issue that we've got is that the plans are showing that the hedge is to be retained. You can't see it clearly on that, but the plans show that the hedge will be retained and that a 1.5 foot path can be provided. Highways don't object to that, and the evidence that Councillor Nichols, or the email Councillor Nichols read out, had not come to officers, so that's sort of new evidence in terms of that, really. I think in terms of the land ownership, it's not directly related to planning, in a sense that the advice we've got from Highways is that the footpath can be provided, and we've got a condition that requires that footpath to be provided, and if it can't, then they're in breach of the condition, effectively. In terms of the point of the other aspects of the access, in relation to Councillor Everett's point, in terms of it being reasonable that require some of the works to be done, obviously construction traffic will need to enter the site, and it's offered view that it wouldn't be unreasonable for the actual sort of access for that point to be provided. But ultimately that doesn't change officers' advice in terms of the footpath. Comes down to officers' view that the footpath is there for pedestrians, obviously, and that those pedestrians are not created from the development until they're occupied. So that is the rationale behind the officers' answer.
Councillor McWilliams, come back on it.
You've got Councillor Alexander first.
Sorry, I just wanted to come back on that.
Yes, come back on at that point, and then I'll go straight to Councillor.
Yes, if you don't mind, please, Chairman. I just wanted to come back on that because what was mentioned there was the what Councillor Nichols had said, and obviously you hadn't had sight of that. Would it make any difference if we were to, say, defer this until you have, and then come back to us again?
I'm not sure whether Suzanne wants to come back or ask me a question in a minute, but all I would say is land ownership issues like this, there's a lot of different ways that you could determine them, and it's certainly not something that, if it gets to a litigious point where they end up going to court over it or various different things to look at, it's not obviously going to be a quick process. But what you've got at the moment is a submission based on opinion at best, and you've got two different opinions, one from a statutory consultee and one allegedly from a QC. They're equally valid opinions, and it's not really the right remit for you to be judging which you think is most valid as such. They're both obviously from professional representatives, if we're to take obviously what Councillor Nichols has said, and I appreciate that obviously officers haven't even seen that prior to this, so it's quite difficult to judge. But yeah, evidentially, you're not really here to determine that matter as such. It comes back to if the footpath is necessary at some point, it's what point that's necessary to you, and obviously looking at the view of what the officers have said in terms of occupation. And if it can't be put in because of the ownership issues, then you come back to a breach of condition. It comes back to the plain planning issue.
Right. You got a few. You got Morris. Richard, I've got you. Richard. So you got Alexander first.
Yes, I've got Councillor Alexander, and then I'll come back to Councillor.
You've got John Hands as well. You got Richard.
Can you do that response first? Is it okay to let Richard go first?
Yeah.
Sorry, Chair, the response.
Thank you. That was really helpful. Thank you, Charlotte. Can I ask then, everything that you've said gives power to the argument that we should be using a condition precedent. So in terms of the two potential conditions in front of us tonight, are they both conditions precedent in Whitley terms, or is one not and the other one is?
Those are the two in front of us.
Just to clarify that I understand quite your question, are you talking about the two alternatives? So the one that you have already decided upon and the one you're looking to vary tonight? Well, they're both similar in terms of that they're both sort of Grampian negatively worded conditions, which do fit with the MPPF generally, but obviously the distinction that we've tried to sort of tease out and that the officers have tried to give advice on is that the very, very fine line between at what point it's required, being at the start of development or on occupation, is the flip sort of weighting as to what seems reasonable and what doesn't, because the reason that the footpath is required, according to all of the information we've got in the report and from the different statutory consultees and the evidence we've got, is that the occupation of those properties is what makes the footpath required. So it's not the fact that the development starts, and that's the very, very tiny distinction between the two.
Thanks for that. Right, so if they're both, in terms of Whitley, they're both conditions precedent, then the one thing happens before the next thing, then either of them in those legal terms could be appropriate, albeit the point that you make about when. So the when issue is absolutely crucial to this argument, I think. And it seems to me that there are two elements to this when issue. If we are looking at, let's take for argument's sake, the proposed condition that we've got before us tonight, that probably wouldn't be appropriate because there is a when for the access that is different to the when for the footpath. And so therefore we potentially need more than one condition, which hasn't been suggested. In fact, potentially a whole load of other conditions around access onto the site, for construction traffic, changing of direction of vehicles so they always come out in a forward gear on the road, etc., which would have been taken care of by the first one because it would have all had to have been done before the development. So there's a complication here, I think, with potentially, if we're looking at making the when later, then there are some other conditions that might need to be put on to this permission to make that possible.
Yes, that makes sense to me. Yes. Yes, please, Charlotte. Suzanne, sorry, I beg your pardon.
Yeah, so just to come back on that point, in terms of the condition that the inspector imposed on the outline consent, he did propose that development shall not take place until a construction method statement has been submitted. And that includes a number of things with regards to wheel cleaning, details of loading, and the provision of parking facilities for contractors, and the provision of means of storage and or delivery for all plants, site huts, site facilities and materials. So in terms of the actual access during construction, that would it be included in that information. Also mentioned in terms of vehicles leaving and entering in full gear, obviously we are looking at the first stage of the reserve matters, which deals with predominantly the access. That information with regards to individual parking and the internal layout would be considered under a future reserved matters application.
Yeah, Councillor Alexander, if you wish.
Right. In response to the officer pointing out to us that she had heard statements made tonight, but there's seen no evidence as a planning officer of this. I'm assuming from that you were talking about the QC's letter rather than the inspector, or I'm not too sure which part you were doing. If you were talking about the inspector, then our own chairman, who can't remember the application so vividly, remarked that there was some issue at the end where the inspector sort of left it down to us to make a decision. That's where I bring in the fact is that we are trying to act in a reasonable way, but we do not have that information before us. I believe Councillor McWilliams has mooted the fact that to defer this until you've got that information. We need more clarity, I believe, on this, and if she is prepared to make that as a proposal, then I'm prepared to second it, because I think we're getting bound down by this, and we're unfair to the developer, and we're unfair to ourselves and to the officers, and I think we need to bring this under wraps.
Councillor Holmes. Right, Councillor Holmes.
Yep, we go back to the same thing. Susan, if we agree this and it works out, I mean, do we know how many phases there are on there? Do we know how they're going to be built, when they're going to be built? Are they going to build 10 houses and then occupy them? Do we know anything like that? If we do, then we know how long we've got before they have to start building the footpath. And is it a condition, is the condition that the first house they build has to be occupied? Or is it in phases? Because if it's in phases, then they might have to finish completely phase one before, you know, anyone gets in there. And if that's the case, they've built half the site or a quarter of the site. If they've built it all and they then come to a bit of a sticky wicket on building the actual footpath, do we have the power as a council and as a building planning to stop it and say, that's it, you can't build anymore? We can do that. And what would be their likelihood? Well, obviously they would take us to court over it, but what would be their position in that?
Right, so there's a number of questions in terms of that. In terms of the timescale and how they're going to propose to build it, we don't have the information about whether if they're building it in phases or if they'll build all 32 out at once. We don't have that information. In terms of the timescale, the only sort of timescales we've got are the standard conditions which the inspector proposed, and that was that all the reserved matters should be agreed no later than three years from the date of the decision. So that was April 2017, and that the development shall not take place later than 2 years from the date of the approval of the last reserved matters. So ultimately they've got a maximum of 5 years from April 2017 to implement the development. Obviously members will be aware we've got no control over ensuring that the development is completed. All we can say is that they need to be implemented. So in terms of the timescale, it's not a question we can answer in terms of when...
Sorry, can't we get a condition if they're not prepared to build the thing first, the footpaths, can we put in a condition that, I don't know, that they build a block, whichever block it is, however many it is, as long as we put in the condition that they build it and then occupy it, and then they have to build the footpath. At least that'll only be a certain amount of the site. It won't be the whole site that's going to be built before they occupy it.
So the way it's supposed to be worded is that they can't occupy any of the dwellings prior to the what is proposed, should I say, is that they can't occupy any dwelling until the footpath is provided. In terms of how they build that out, that would be at their own risk if they wish to build 10 or 32. And going back to your question, ultimately that there is a condition if they chose to build out the development and for whatever reason the footpath could not be provided, we're in a breach of condition situation. So ultimately, as a last resort, we could say you're breaching the conditions, you can't occupy the dwellings, demolish them, please. I mean, that would be the ultimate, risk that they would take, and if it came at that time, that would be a judgment that the council would have to make at that time.
We could make them demolish it.
Yes. Yeah. Ultimately, that's what we could do.
Chairman, can I?
Yes, Councillor Baker.
I knew this would take some time. I think I brought all my old notes, and when we decided to change the condition last time to what Councillor Everett suggested, I've just scribbled down here. It says, if could not comply with condition 2 that was proposed at the time, which is the same as we have in front of us, could come back and ask for amendment to permission or implement another way. And I think, if I'm right, my colleagues' concerns were that if we had the condition, as we have before us tonight, that the footpath is provided prior to first occupation of the first building, whether one goes up or the whole lot, that when they then find out they cannot implement that condition, they will come back and try and get that condition discharged, which then sort of defeats the whole object, really. So, and I think that's the reasoning that we gave, if I remember correctly, as to why we went against officers' advice and decided, and I think Councillor Everett actually came out and said he's doing the developer a favour and sort of thinking of him as well and being generous in that if they can't do it, then they can't build. And I think I still agree with that. I'm just looking on page 56 at paragraph 6.6, which mentions about the paragraph of the NPPF that the conditions should only be imposed where they are, the 6 conditions. I think we hit all 6, which is obviously it's necessary. Well, it must be necessary because there's a condition originally. It's relevant. It's relevant to the development to be permitted, and I appreciate what the officers have said. It's enforceable, it's precise, and we have to ask ourselves, are we being reasonable in putting that forward? That's not a question, it's just a statement.
Councillor Everett.
And picking up on that very point, I think even the developer recognises that because their letter is quite clear. It says, care should be taken when considering using conditions that prevent any development authorised by the Planning Commission from beginning until the condition has been complied with. This includes conditions stating that no development shall take place until or prior to any work starting on site. Such conditions should only be used where the local planning authority, us, is satisfied that the requirements of the condition, including the time of compliance, are so fundamental to the development permitted that it would otherwise be necessary to refuse the permission. I think that says it all. We are worried. We are really seriously concerned about this whole application fundamentally revolving around this issue. That makes it go to the heart of the permission. That makes it legally able for us to do what we decide we want to do with that taken in mind. So I think even the developer recognises that. They say it in their letter.
Right. we haven't considered, I think you've passed it to one side, my fear that that road is already bad, but it will be the final thing that will break the camel's back will be the development traffic to this site. And therefore there is an exceptional reason why the footpath should go in early rather than afterwards. And if that needs enforcing, then that would be certainly the way I would look at this application. I don't like this sort of threat that we do get, but undoubtedly it's better if it comes out in the early stages. What happens if this goes to appeal? There is a chance that if it went to the appeal and the inspector, and they're a funny bunch, the inspector chose to support it and awarded costs against us. Now that is one of the things that we must take into a consideration if we chose to stick to the recommendation that we used last time. But to the conditions of the reason for supporting what we said last time, I would suggest that we have got to consider the construction traffic, not just that footpath as is, but we've got to consider the extra traffic that will be needed up that road. Councillor Holmes.
The inspector's already been involved in this one and he gave his permission, he allowed the appeal. That appeal was for what was stated up there, is that correct? The whole of the site as it is that we passed last time?
In terms of what the inspector approved, he approved outline permission with all matters reserved for the construction of 32 dwellings and an area of communal facilities on the site. So he didn't consider the access and he made it perfectly clear that it was to be considered as part of reserved matters application, which is the applications you had before you in February and again in front of you today.
Can I come? So did the builders have the right of appeal on this? If we say no, we'll go to the original one, can they appeal against it?
So ultimately they would have, they've still got time to appeal against the condition that was previously imposed by members on the consent, and if this application were to be refused they would have a further 6 months to appeal the decision that is made. So they would have a right of appeal.
Right, so we'd be putting it back into the inspector's hands?
Yes, you'd be putting it back into the inspector's hands, and members should be aware that if it goes to appeal then there is potential for awards of costs. So that's something to bear in mind.
Yeah, I hear you on that, and I always hear the potential for costs. Sometimes it costs us money, sometimes it don't. We're put in this position to make these decisions. We shouldn't be inhibited by the cost. We either make it or we don't.
Yeah, yes.
Yeah, I think just the point that Suzanne was trying to make, obviously it's another thing to put into your balance against, the things that you're considering. So you have to, it's part of your duty to consider the potential for costs against you if the matter goes to appeal. And that would obviously be on the basis if the inspector thought that what you had done was unreasonable. That's the reason for awarding costs. It's not a standard you lose. If the inspector goes against your decision, it doesn't automatically mean that costs are awarded against you. It's if you're seen to have acted unreasonably, and obviously he would look at all of the evidence and the advice that the officers have given, and what you've chosen to do with that advice and how you've come to your decision would all be examined if it got to the appeal stage.
Right. No further discussion. I think we had indicated that Councillor McWilliams wanted to defer, and that was possibly seconded, I think. I'll put my two pence in. I would vote against deferment because I think we've got to grasp the metal, we've got to make our mind up. And I, for one, don't want to go back the 5th time to measure that road. Let's be positive. Either we go with it or we go with the officer's recommendation. But am I right in assuming that there is a proposal on the floor for deferment?
Chairman, can I just confirm, because one or two didn't hear what you actually said just at that moment. You said either deferment or agree with the officers. Is that what you said?
No, sorry.
That's what we heard.
I said I would vote against deferment, full stop. So that we have a positive vote one way or t'other.
Yeah, I agree with what you're saying, because after the discussion that we've had here now, we are in a very tricky position. I don't know if officers have got anything else that they want to mention to us, but I mean, we could be sitting here for another hour keep going over the same thing.
Yeah. Right. Okay, so the proposer then for deferment, as I understand it, is not putting that, which means, I don't know whether anybody else. Councillor Everett.
I'd like to propose that we refuse this application.
And the proposal will be worded along exactly as it was last meeting. Right, so we know what we're talking about. I'm going to, ask Head of Planning whether she wants to add something to that.
Chair, I don't think we ever got to a reason for refusal last time because we imposed a particular condition. So there might have been a justification for that, but not a reason to refuse. So that's one thing. While members are thinking about what that reason for refusal might be, it's perhaps just worth recapping over. By granting planning permission before with the Grampian condition that said prior to occupation, there's an acceptance in that, I think, that a Grampian condition to control the timing of a footpath is acceptable, is appropriate. The council are sort of saying we think it needs to be provided, we think a condition to do that is reasonable.
Before occupation?
Well, just the principle of a Grampian condition to control provision of a footpath is an acceptable way forward. And so to impose a reason for refusal now, which was contrary to that, would obviously increase the likelihood of the developer crying foul and looking for costs. And I think although I think a lot of the discussion tonight was actually about the reasonableness of imposing that condition rather than the trigger point. I think you're trying to use a trigger point because you feel uncomfortable about the reasonableness of the condition overall. Okay. I think you've suggested tonight that because of land ownership issues, it's not appropriate to attach a Grampian condition to control the footpath. And what you're doing is you're suggesting requiring it very early on in order to sort of flush that out. But if you think that condition wasn't appropriate, it perhaps might have come to that view last time around, because that side of it.
I think, actually, to the contrary, that the Grampian condition, the rationale for using the Grampian condition is because of that. Safety. In that, the NPPF guides us that where the land ownership is not under the control of the applicant, then a negatively worded condition can be used to do that purpose, because a positively worded condition will not be appropriate. And so therefore that's where the Grampian condition comes in. So to the contrary to what you say, that's about the rationale for the Grampian condition. It's absolutely clear, in my mind at least, that it is appropriate to do a Grampian condition. Further than that, I think that it is not only appropriate to do the Grampian condition, but that the timing of it is about compliance, and that we see this condition as going to the very heart, and that's what the law keeps going on about, the very heart of the permission, that otherwise, if we did not have that condition, we would have wanted to refuse the reserved matters application. And that legally is sort of, as I understand it, I'm sure I can be corrected, is the rationale behind why it is we want, one, a gramping condition, and two, the timing of that gramping condition.
And safety.
Solicitor's advice on that?
I've kind of given it earlier on, and my view hasn't changed. It's the opinion of the officers that impose these conditions on a regular basis and see them sort of challenged through various processes, that the distinction between the imposition of the occupation element and the development element is something that could be viewed as unreasonable because of the reasons that have been given and spoken about at length tonight. It is, of course, up to members to take the contrary view. It is an opinion. But it's an opinion obviously grounded on their knowledge, and you're entitled to take a different opinion grounded on the knowledge that you've got and your reading of the situation. I think if I don't want to complicate matters anymore, but I think my understanding of sort of the point that Kath was trying to make is you can't use the occupation development distinction to try and get over the fact that the footpath, let me word that slightly differently, to try and police whether or not they're going to go ahead and do that, develop without the footpath, because you're trying to sort of you're preempting them doing something that's against the planning permission in any event. So the new condition as proposed or asked for in the planning permission would not allow there to be people in those houses or those houses to be occupied at any point before there was a footpath. And what I'm getting from you is your concern is that that's what's going to happen, and that still comes back to an enforcement issue. And I can fully appreciate why you're concerned, and it's very clear that the footpath is of vital importance to the occupation of those dwellings, but I'm still not sure that we've got a clear reason as to why it's required for the development of those dwellings. And I think that's just what we keep going round on. Now, we can obviously use the reasons that you've given, that's not an issue, and that's what we'll do. But I think that was what Kath was just trying to thrash out. I think she wants to add a bit more too.
No, it's only just, I think I said what I said, and obviously we've got a different view about that. But I think if the committee are minded to refuse, we just need a reason for refusal that explains really clearly why prior to occupation would have been acceptable. No, not acceptable, and why prior to commencement is acceptable. Why is it essential that it's prior to commencement of development rather than prior to occupation? How is that reasonable?
Could we say...
John.
Yeah, I've called John, yes.
Yeah.
Microphone.
Could we forget about occupation? Just say that we as a committee believe that the footpath is an integral part of the building and the thoroughfare and the safety of everybody that would be involved in the building. Forget the occupation. We believe that the footpath should be put there because of a safety aspect and the amount of traffic that will be using that road now.
I'd like to see something similarly worded to that to be added to it. Councillor Bennison, do you wish to add something?
Thank you, Chairman. It's just something that's just leapt up at me on page 58, Essex County Council Highways. They have indicated that there are public right-of-way routes leading to the village, so therefore the footpath wouldn't be used very much. But we were told in no uncertain terms on our site visits that there is no access at all from this site through adjacent sites. So all pedestrian movements will come down that road. So rather than being very limited amount of pedestrian traffic, there will be a lot, 32 houses worth of pedestrian traffic and no other pedestrian route into the village. So it's even more crucial that we do have that footpath in situ before they even think about building these houses.
Yes. Right. Give anybody the last two penneth before we put the vote. I think this has indicated that she's got a number of points that we can use.
No, sorry, just to clarify, I don't think we've got that clear distinction as sort of Kath. That was what I was trying to say, and Kath sort of summed up. We've sort of been between what is the trigger point difference between the two trigger points that is of utmost concern.
Councillor Holmes has indicated one of them, the additional construction traffic that's needed to be put in there because it's a badly loaded road as it is, and it would be even worse with the construction traffic. Therefore, we want the footpath in straight away. Councillor Everett, as the proposer.
If I may, can I ask officers, clearly there's an issue here that we need to deal with in terms of the justification. You've heard the debate tonight. Can you advise us on what we ought to be putting in those conditions, in those reasons?
What number is that?
620, 621.
Might just help to doubly clarify. So is it what you're saying that the development itself will cause an increase in the construction traffic, which will be a hazard to the pedestrians that are occupying that road or trying to walk along that road? Is that what you were trying to say?
That's one of them, yes.
The amount of construction traffic that would use that road, how many houses? 39, is it? 32. Would be quite a lot. Roofers, brickies, plasterers, chippies, they'll all be there. They're all going to be using that road. So if there is nothing done about it, from that entrance point to the main road will become a chicken run. I mean, the first time any accident happens down there, and it would happen, would definitely happen. We see it today, so I can believe that that's quite a pertinent, proposal. Maybe not.
Right, well, I'm not sure whether the officers are bringing anything further forward, but let's start with the proposal to refuse, which we have in front of us, and it will be worded very similar to the wording at the previous meeting. Now we're looking for the extra reasons why the footpath should be put in before the work starts, as against waiting for the work to be done and before it's occupied. And the access, yes.
Sorry, just to confirm to members, from the discussion, our officer's understanding is that you're looking to refuse this current application on the basis that the additional construction traffic generated by this development would cause a hazard to pedestrian safety. You've either got to make a decision, you can't amend the condition in any other way, or revert back to the old condition because that condition still stands. I think from the discussion, our view is the only way forward is to refuse on the grounds that that has been discussed.
Cross our fingers.
Right, Councillor McWilliams.
Can I just say, I'll be honest, I just don't think that's strong enough. I really don't. I don't think I'm the only one that's thinking that at the moment. Seriously.
I think the only thing I can add on to that is that obviously it comes back to what would be looked at if it was taken to appeal. And I'm not saying that the developer will appeal the decision, but obviously it is a risk. Presumably they would look at what the highways have said about current movements, what they would calculate to be future movements for construction traffic, and they would look at that evidence as part of the analysis. As far as I'm aware, we wouldn't, other than your viewpoint about the construction traffic and the safety impact, we wouldn't be in a position to put forward any additional evidence on that basis unless we were to instruct somebody to try and come up with that evidence. But obviously we don't know that that would be supportive of what you have concluded, and equally that would obviously come at a cost. So you just have to take a step further if it is challenged, just think about how you might evidence the conclusion you've come to, because that would be the sort of evidence that the inspector would be looking at and that the applicant would certainly put forward. I mean, just looking at what the highways have said sort of around about page 58 and a bit before that, at the moment they've given a viewpoint on the movements at present, so that would sort of be the same information that they would look at again based on their modelling of what that new development of 32 dwellings would generate in terms of movements.
Yes, Councillor Benson.
Thank you, but as I mentioned before, that evidence, Essex County Council evidence, highways, is flawed because they're basing that level of foot movement on the existing public rights of way, which aren't accessible to this site.
That's your view based on what they've said there. I'm just saying they would obviously, we could put that to them and ask them to come up with another analysis. But I'm just saying that that's the kind of evidence that the inspector would be looking at. And there's nothing to say that highways would support your view or change their view. All you can look at the moment is what that's just what you have to think about, is how you would evidence what you've said.
Yeah. Councillor Baker, and then I'll take Councillor McDougall.
I'm just looking back at the our agenda from February when we made the decision, I think. And highways won't change their mind because they use this fantastic computer system that looks at something that's similar somewhere else. And they decided that only 5.5 pedestrians per peak hour. Well, I remember a member of the parish council was there and he said, that's absolutely ridiculous. He said, there's 30 plus people use this, not necessarily every hour. But the problem is that's a pre-existing condition. And the officers have highlighted that in paragraph 611, that we can't do something to impose a condition to sort of make a pre-existing condition, i.e. lots of pedestrians use it now, because it's not created by the development. That's what I'd point that out.
Can I just say something on page 58?
Hold on. Go through the chairman.
All right. Councillor? Yes, McWilliams, Councillor.
Thank you, Chairman. In view of what our solicitors just said, I'm just wondering if we should go back to deferment again, just to get everything in place, just line it up so as we know exactly where we are. I'm just wondering if we should do that. I don't know what everybody else will think on that, but we do need something a little bit stronger, because I understand what is being said, that it could go to appeal, it could end up being a financial cost to us. But if we could actually prove that there is a situation that we need to put forward as a good reason for refusal.
Councillor Hone, you indicated.
Yeah, I mean, it's on
microphone, John. Put your microphone on.
On page 58, it says, during the have been consulted the application, raised no objections to the application, follows previous, and would confirm that they consider the new footway, albeit of a lesser width than normal standards, will not only provide a suitable refuge for the very limited number of new pedestrians, but will also be of benefit to those existing pedestrians who already use Tye Road. It gives it itself, you know, they say itself, they're quite happy with it to go through. as a footpath. I can't see what problem we've got with that. And we make them do it first. It's not that big a problem, is it? I wouldn't have thought so.
Well, in terms of the previous consent will still stand if this application is refused, so they'll still have the requirement to do it prior to occupation or prior to commencement of development. I mean, it's the same with anything. They can put in an application and we've got to determine as it stands. I mean, I think the point of deferral, I think really you've got to be clear on what you're deferring it to achieve, because effectively if you're talking about land ownership, if it's then proven that it's not within the ownership, then you prove that the consents are invalid. So actually it has no direct bearing on this application, because you then prove that if it's outside the ownership then they can't implement the previous consent either.
Sorry, can you explain that again? I've got lost
I suppose
in the middle there.
I suppose listening to your debate, the concern is that the footpath can't be provided because it's not within land ownership. So therefore, my query is, if you're deferring it in order to get an answer to that question, if the answer comes back as into no, it's not within that ownership, then they can't implement either of the consents.
Which makes it true condition precedent. Means that they can't build. Which is what we want.
Of course, just to throw another spanner into the works, if you think of any footpath, it's all on privately owned land. Any other footpath, it's established use over somebody's private land. So that's another bit that might happen here. Right. Yes, Councillor Cawthron.
Thank you, Chairman. Just an observation. If we were to defer through this question of land ownership, that could take many, many months or years to be settled in court. It's not going to be settled in a deferment for a month, is it?
No, that is true. I'm going to try something that Suzanne's just said, which has started me going, because we're saying that if we refuse this application, the refusal that was granted in April still stands. Oh, the condition still stands. So, in other words, whatever we add to it tonight, he could go to appeal tomorrow with whatever reasons we gave the first time round.
I don't think that's quite correct, because my understanding, and I bow to officers' greater knowledge, is that for conditions it's 12 weeks, not 6 months.
And they've got 6 months in which to appeal the condition. So they're still in time. They could submit an appeal tomorrow.
Yeah. So he can go tomorrow, even if we can't find anything to hang on it tonight. He's already got the chance to go. Yeah.
Where exactly is this leading us? Because we appear to be running around hedges here. Can we just bring this to a conclusion, please? I think that motion should be put. We agree that we've agreed amongst ourselves and entirely that we are acting what we believe to be reasonable, considering that the inspector did not make a decision on this but left it to us to do it. And I do not think that we are acting outside of that, simply because, again, I'll make it blatantly clear that they are prepared to build and then do a pathway. But what is the difference between doing it either way? if they had come back and said, look, we don't actually own the land at this moment, but we're negotiating it, this would have given us something to go on. But we are dealing, as you blatantly say, Councillor McWilliams, that we are dealing in the dark. We don't really know what's been said. We keep being told how it's going to cost us money and we'll be in front of these inspectors and all that. And I wonder how many delegated decisions on refusals also end up there, and is that given consideration? Sometimes you have to take a risk. And I think that's what we're here to do. And that's why we've been put here. We show leadership.
That's getting nods. Right, Kath, any final point to add? Yeah, righto. I'm just going to ask the solicitor now to read what she's got and what
So just to confirm before we take the vote, it's a motion for refusal. So Councillor Everett moved for refusal, Councillor Hone seconded it, and the sole reason for refusal that we've got at the moment is that the construction traffic from the development, so from the point the development starts, will increase increase danger to pedestrians that are currently using the road, and therefore that's why the footpath requires to be put there for development, not prior to occupation. That's what I've got down at the moment. If there's anything to be added, then this is the point to do it before the vote's taken, please.
And the concerns over the land ownership issue of the hedge, and so therefore that this goes to the heart of the Commission as to whether it's even possible for it to happen. Susan, goes to the heart of the Commission.
Yeah, he's right.
I just wonder whether that additional bit will muddy the water if we're... but it is a reason, undoubtedly, that one of the points that we're looking at, but whether it's the principal reason to bring out or not, I'm not sure at this stage, because it is an argument between two professionals, if you like.
It's not a planning consideration, is it?
No. And in fact, I'm not so sure it's a planning consideration either. So, right. I'm in the hands of the proposer, whether he wishes to add that.
What's the rationale for not adding it again?
I just think it's not a very strong point in that it's an argument between two professional bodies and it might muddy the water. Whereas we've got a concrete point about the additional traffic could create the entrance exit and the additional load on Tye Road.
An officer's advice on that is?
I would advise you to stick with the first reason for refusal.
Okay, and John was the proposer, I think, of the additional item, so, and the seconder of the main motion. So you're happy with it going with that on that one? Right, okay. Hopefully you now know what you're going to vote on. Those in favour of a refusal on this and the additional points, please show. Right, 1, 2, 3, 4, 5, 6. Thank you. And those against, please show. 2. And that means there is one abstention. Two abstentions, right? Okay, so that is refused. Thank you, I think. Quick comfort break then. Very quick, please. Yes. 3 more applications to go. Can we get on, please? Right, draw your attention now to agenda item 7. It's A4, planning application. It's from TDC, and that's the reason it's in front of us. It's the cliff slope between Hazelmere Road and Queensway on the seafront. And we all enjoyed our visit this morning in the sunshine. In fact, it was a job to get you away from the site, but there we go. Right, turn to Head of Planning, I think, who's got this one.
Thank you, Chair. Yes, as you say, this one's before you because the Council are the applicant, so the Constitution requires it to be reported to Planning Committee. Large sections of the cliff have been identified as failing or as unstable, and some footpaths have had to be closed for health and safety reasons. So the works that are proposed include the installation of drainage within the slopes, removal and replacement of walls, regrading of the cliff, landscaping, sheet piling, retaining walls, access ramps and footpaths. So pretty extensive works along that stretch of coast. There are 4 areas have been identified for the works, and there's 2 in this red area here and 2 others further down closer to the pier there. For areas 1, which is the majority of this area, the western part of this area, and for area 4, which is the other extreme, the majority of that end, the works are actually fairly minimal. Once done, then the resultant appearance of the area will be fairly similar to they are now. The more significant changes are to areas 2 and 3, which are the far end here and the eastern end of this section, and I'll take you through the details of those in a few moments. That's the same view basically, but obviously the aerial photograph rather than a map. It's important to remember in terms of policy that the greensward is actually designated as existing recreational open space, so that's something to weigh in the balance when you're determining this. And it's also designated in a similar way in the emerging plan. That's just the as existing, showing you the current profile of the cliffs and the drainage, and then the proposed plan showing the blue lines are drainage, it's new drainage going down the cliff, and then there's also new drainage going across the cliff. Again, I'll show you a little bit more detail as we go through. So this one is 1B, this is section 1, and it includes removal of the wall. Now, this is the area where the beach huts will need to be removed while the works are going on, because you can see there's a line, this line through here is sheet piled wall. So those beach huts that are in the front of there will need to be taken away, put in a safe compound and returned once the works have done. It was expected these works would start earlier this year, but they're due to start now towards the end of August. The owners of the huts have been notified. They've had all their ground rent for this year refunded as compensation. So obviously it's not ideal, but the works in total will take best part of a year to some extent. Whatever time of year it starts, there's going to be disruption through one of the summer seasons. Okay. Photograph of area priority area 1. You probably stood up on this sort of node here this morning and looked along it, did you? Okay, a little bit further along. Yeah, you can see the reptile fencing there, so there's some evidence that the ecological survey work has indeed started. The preliminary ecological appraisal confirms that the site is suitable for terrestrial invertebrates, nesting birds, reptiles and small mammals, and it makes recommendations about further survey works for the various different types of wildlife on there. And it also makes, as well as those species, it makes recommendations for badgers, birds, waterfowl, etc. And there are conditions recommended that would reflect that ecological assessment. So there are the beach huts in that particular area. You can see one of the footpaths going up the cliff there. That would be reinstated as part of the scheme. So that one was area 1, just to remind you, where there's actually the resultant appearance will be relatively unchanged. Area 2, this is the easternmost end, is one of the areas of most significant change. So at the moment there is, what's proposed is to put in this quite substantial footpath and the large graded path up, which would be really accessible for people in motability scooters, people with pushchairs, etc., etc. And this scheme is to deal with failure of a large area of concrete sort of embankment there, which you may have seen, which is already cracking and failing. No, the surface is tarmac. It's asphalt, either red or black, to match in the existing. No, it's just been coloured grey on there, which does give it that kind of metallic appearance. Okay, so this is that section 1, and that's the concrete, which is quite steep angle at the moment and is failing. In order to be able to, give that a more gentle grading, some greensward will be left. So hopefully you can see 2 yellow lines, and that shows how that's the first one is the new cliff edge, and the second one would be the alignment of the path. So rather than the path coming out, kinking out like that as it does now, it will go straight through. So this area in here of grass, that little width there, would be lost. Okay.
Is that to get the incline?
That's to reduce the slope. Yeah. And there's a landscaping scheme for that area, so it's a mix of shrubs, trees, and grasses and wildflowers. So that's looking further along back to area 2 again. Again, the area of greensward to be lost would be in here, just where it kinks out. And that's the area where that large ramp would go in. And now this is areas 3 and 4, so we've jumped back down to the western end, closer to the pier. That's as existing. This area, this shows you the proposed plan. Again, it's to regrade it to a more gentle slope so that it's more stable. And again, that would mean some loss of grass. So whereas at the other end, even though you lost some grass, there was still a significant amount of greensward left. At this end, there was only a very narrow strip of grass, and that would be lost in this scheme. So the footpath would come up against the road, and there wouldn't be grass. This green is actually the slope down towards the sea. And again there, that shows you the existing position, and the footpath would have to be moved on to where that grass is at the moment. Yeah, because there just isn't the width there to be able to regrade it sufficiently without doing that. And that shows you the regrading. So that's a photograph of that area.
Is that the bit that's got to go right to the right?
Yeah, that bit would be lost. That bit of grass there would be lost. Okay, looking back in the other direction, this tree would be lost because that's obviously that would be graded out, as it were. The grading would start here, but that tree would be retained. Okay, proposed plan for 4, and in that area, because it's still relatively steep, these are anchors going into the bank, going into the cliff to help anchor the soil in and make it stable, and then there'll be planting over that. And they're in a grid about between 80 centimetres and 1 metre apart from each anchor. There's like a big grid of them across that slope. Now, priority area 4 is actually within the conservation area. And so for this area, you need to weigh up the any loss of value to the heritage asset compared to the benefits of implementing the scheme. Perhaps, fortunately, in that respect, this is actually the area within the conservation area actually doesn't have greensward. It's already just footpath and then slope. And so in terms of character change, it's relatively small. And the officer's view is that any loss to the heritage assets is outweighed in this case by the health and safety issues associated with the unstable cliffs. Similar view, and then that's just a very detailed scheme showing you the existing profile and then how it will be regraded for section 2. So that's down the eastern end, and again in more detail. Okay. Not sure which is the best of all of these plans to leave you with. Perhaps the overall one. So, Chair, it's considered by officers there are no adverse on balance. The improvements we feel are necessary. The changes to the appearance of the area and to the ecology of the area will, over time, be sort of quite minimal. The ecology impacts can be mitigated. There are no adverse comments from Environment Agency, Natural England or the County Council in terms of ecology. We've sent out 299 neighbour letters, but we've had no comments submitted back. So there's no opposition to this that we know of from the public. So consider it to be acceptable in terms of its impacts and recommend approval.
Thank you very much. I think the discussion point will be based basically on timing. We did hear from Mr. Enos this morning that part of the stage, although we want planning permission for it, part of the stage will be deferred, I think. As I understand it, that the contractor's price is way over the estimate for the western end. I don't know whether that was members, they understood the same thing as I did. Yeah. Howsoever, timing, I know, is a point that at least one or two of you want to bring up, so it's open to you. Councillor Alexander.
Thank you, Chair. I have to say, I'm very impressed by this, actually, and I'm glad that we are taking the initiative on this, because the cliffs are important to us in so many different ways, and if we ignore that, we have only got to look at Pakefield and Hemsby to see what happens if you don't act very quickly when you need to. So I congratulate the officer for moving with such speed and delivering this to us. I believe it's sensitive to the conservation area, but it's a necessity. You've got to work out, do we leave it as it is and it disappears, or do we something about it and then cut into that? And then it will naturally regrow. So I'm quite proposing to move this as it's laid out, this application. And the area of concern I have is the start time. This whole air show thing, you know, that it's apparently, according to the officer this morning, they were thinking about starting it at the very weekend that the air show was going to start itself. And that was causing some concern. So I don't know whether or not that's been addressed now. I've been poked a bit of paper in my face. So I just wondered if you'll bring that up. But I'm prepared to propose this as laid out.
Councillor McWilliams.
Thank you, Chairman. Yeah, it was good to see that and have all that information before us this morning and see how the wild creatures would be. We got that explained as well. The only thing I didn't ask was where do they go? I know they're taken away, but I didn't know where they went. But apart from that, it was very interesting. As Councillor Alexander has said, great, we must get it done. It needs to be done. Fortunately, we can afford to do it as well for various reasons. And yeah, I will second that motion of approval.
Councillor Everett, thank you.
Thank you. I echo exactly what my colleagues have just said, and particularly I think we may actually have the answer here to the timing problem, because in the briefing on our green papers it says that beach hut owners have been told that they'll be closed from the 21st of August, and of course the air show is on the 22nd, 23rd and 24th. But it gives a bit after there saying prior to moving the huts to their storage compound, internal and external condition surveys will be undertaken between the 21st and the 31st. So therefore it would be possible to not fence off those beach huts until after the air show with no appreciable upsetting to the timetable, because the beach huts would be able to be accessed without the Harris fencing being around them. So I would like to propose a slight amendment to that, that the Harris fencing not be erected until after the air show.
Right. That's a suggested amendment, which, now, any further discussions? Yes.
Thanks, Chair. Yeah, sorry, I forgot to bring the green sheet to your attention. Firstly, the committee papers only showed half of the site, so it only showed you priority areas 1 and 2, hence we've put in areas 3 and 4 in the plan here. In terms of the coastal erosion, this scheme is not to address coastal erosion, so the coast is protected by the works that are already in place. But this deals with the cliff erosion, but it's not being impacted by the sea. It's true that sections 1 and 2, I understand, are sort of fully funded, and the plan is to proceed with those imminently. 3 and 4 may or may not come ahead at some point in the future. But obviously, if you grant planning permission and the scheme overall is started, the planning permission will be extended for the whole scheme. And in terms of timing, I think that's although we've been given some information about when they intend to commence, it's not really a planning matter. And there may be contractual issues. I think there are contractual relationships between the beach hut owners and the council as the landowner. And obviously that's well outside the remit of this committee to deal with those issues. And there may be contractual issues between the council and the engineers doing the works that might be a reason for this timing. I really don't know, but I think really planning committee we need to try to stick just to the planning merits of the case. I'm happy to take a message back, if you like, a separate note to the people running the scheme to say there was some concern about the impact on the beach hut owners, but I would steer you away from trying to amend the proposal in that way, because the timing is not part of the planning proposal.
No, thank you for that. I think that is important that we do it that way, because we do anticipate another 100,000 people a day coming to the air show, and but I think the guarantee is really given. If you read on the green pages, the fencing would be erected on the 21st of August. If that could, we'd like that deferred for a week. The main works won't start until mid-September, so that's really what we're suggesting. Councillor Alexander.
Well, as the original proposer, first I'd like to say I'm fully aware of what work has been carried out along that stretch to strengthen and to recharge the beaches. I'm more than aware of it, but my mind goes back a little longer than most, I think, way back into the 50s flood. When the big guy wants to take it, he just comes in and takes it. He doesn't bother about what you've done to prevent him doing it. And the more we can do to protect ourselves, the better. And we are protecting ourselves, and that was the basis why I went for approval. Right, I'm happy to continue that, Chair, with the amendment made by my colleague here, and that's it. I'm prepared to do that.
I suspect he might be going to remove it with as a suggestion, but I may be wrong.
I think it would be possible by what Kath just said to do an informative or something, really just accentuating the point that we'll look bloody idiots in the front page of the local gazette, closed off 2 days before the air show isn't going to be a good look.
No.
So just to make that point, I think is sufficient. Thank you.
Yeah. Good. Councillor Brown.
Thank you, Chair. Yes, it could be put in a way to the company that's doing it that it wouldn't put them in good light too, just as an extra persuasion.
Yes. I'm sure we've got means of doing just that. Yeah. Right. No further discussions then. Have we a mover and a seconder? The mover is across there, and the seconder was Councillor McWilliams. Those in favour, please show. Unanimous. Thank you very much. That is approved. And we now move on to A5, which is again a TDC application. It's application number 1800613. It's a full application for works at Barnes House, 92 Pier Avenue, Clacton.
Thank you, Chair. I have remembered the green sheet this time. There is a slight alteration to the description of development. So the reference to 9 deeper window profiles on 86 to 90 Pier Avenue has been inserted into the description of development. So as well as being the extension at the rear of Barnes House, a link between the two, it's also some new windows. And the application is before you because it's another TDC application. So the site is on the east side of Pier Avenue. It's made up of 2 buildings. There's Barnes House, and then there's the larger, Barnes House is a sort of Victorian villa building, and then the larger office building is quite relatively modern, and both are currently used as offices by the council. And the proposal is to build a first floor extension over an existing ground floor extension in that location, to bridge between the 2 buildings with a 2-storey extension, and to replace first floor high level windows along this elevation with larger windows. The site has a link through from Pier Avenue, sort of down the site through to the Wellesley Road car park in that location. There's no car parking proposed with this proposal, although it's an increase in floor space, but it is a town centre location and it is immediately adjacent to that public car park. There's the aerial view. And it's got a typical mix of town centre uses in this area. So there's an education centre next door there. I think there's an optometrist a little bit further along. Boots the chemist in here and other shops. There's a doctor's surgery around the back. And then actually as you move up here, Wellesley Road, they're more residential in character. Mixture of houses, flats and maybe HMOs as well. And officers have looked obviously at the potential for overlooking, but given the mix of uses, the angle of the building and the distances involved, we don't think that would cause a significant problem. There are already windows in the back of the office building, and these overlook mainly the car park here, but also to some extent the back end of residential gardens, but it doesn't significantly worsen the existing situation. So that's a front view. There's Barnes House. There's the larger office building. So the proposal is to put the link in there and then to build on the back of this building here. There's the rear view. So that's the existing rear single-storey extension. Proposal is to have a flat roof first floor extension above. These are the windows that are to be enlarged. So rather than being high level, they'll be larger just to let some more light in and make the office inside a better environment. And again, you can see the relationship there between Barnes House and the neighbour. The first floor extension will go on here. So there will be some overshadowing of the rear garden of this property, but it's actually used wholly for car parking to the education centre, so it's not a residential garden. So that's the neighbouring property that I described, and then this is where the first floor extension would sit on top of there. And lastly, the elevation. So this is existing on the left-hand side and proposed on the right. So you can see the separation of the buildings at the moment. They would be joined by the two-storey extension, which is set back a little bit to sort of keep the integrity of the existing buildings. There's the extension to the rear. Okay. And those are the floor plans. The materials would be broadly to match existing, so some render and brick banding to match the design of the existing one. We have no third-party comments or objections from consultees in relation to this application, and the recommendation is for approval.
Thank you very much. We all saw it this morning, so councillors, it's up to you. Any discussion points or any proposals? Yes, Councillor McWilliams.
Sorry. I wasn't going to go for really much discussion because I think Kath has outlined it quite well. It's obviously something very significant for the council, improve certain areas as well. Allows for officers to have somewhere nice to work. I don't know what else I can actually add to that, but I would like to move approval.
Councillor Holmes seconded. Any comments? No further comments. I'll put it straight to the vote otherwise. Right. Then the proposal is acceptance with a time limit, materials to match Barnes House, and to stick to the approved plans. Those in favour, please show. It is unanimous. Thank you very much. It is approved. And now the A6. It's planning application 18-00659. It's a full application for March House, Clacton Road, Thorrington. Head of Planning taking this one?
Yeah.
Yes, thank you.
Thank you, Chair. So this proposal is for an annex building to provide living accommodation within the rear garden of an existing dwelling. And it's being reported to Planning Committee tonight at the request of Councillor Nichols. That's the site location plan. You'll see the application to the site to the south of Clacton Road. The dwelling is located to the west of an access track that leads down to sort of tennis courts and an open area to the rear. There's the aerial view, so you can see there the relationship to other dwellings, all fairly substantial buildings along the south side of the road there, with quite generous gardens. There's the lane that comes down the side of the property. You can see the tennis courts, allotments, etc. So fairly open, sort of rural character to the rear. And then a few photographs. Well, you will have seen, it wasn't looking like that today, was it? So this was on a rainy day. There's the lane to the side, so this is the application site here, and the proposed building is to be sited at the back of the garden there. So that's looking through a missing fence panel from the lane into the site, and the building would be located at the back there. There's another view looking straight onto the back of the site. The track is down the side there. So again, the building would be just the other side of this fence. And there's the block plan. So it shows the existing house towards the front of the site, track to the side, and then the proposed building is located at the back of the site. So there's no independent means of access to the proposed building. It is quite close to the boundary fences on the three sides. And it leaves a garden space for the dwelling, which does comply with the council standards in terms of garden area, and there is sufficient parking and turning for the dwelling. The building that's proposed is single storey, and it measures 4.9 metres to the ridge, and is 8.1 by 9.1 in plan, and the eaves are 2.6 metres. So the eaves at 2.6 metres would be visible over a 2 metre high boundary fence, but given its location at the end of a garden with sort of open areas behind and to the side, officers feel that wouldn't be overbearing. There would be no overlooking caused by the property to any neighbours, albeit that the top part of the building would certainly be visible from outside the site. And there are the elevations of the proposed building, fairly typical, sort of modest sort of annex building, a single storey, as I said, so no overlooking. And there's the layout plan showing it would have one bedroom, a lounge, and then a sort of open plan kitchen dining room area and a bathroom. That's a superseded design, so that's how the application came into the authority with the bedroom accommodation upstairs, but that was superseded for that design. The materials are fairly typical brick and tile. We can control the details of those. The recommendation is for approval, subject to conditions, including one that the accommodation could be used as an annex only to the main living accommodation, not as an independent dwelling. Thank you, Chair.
Thank you very much. Now we have speakers on this. Representing the Parish Council, Councillor Andy Sandler. Right, so well, welcome to start with, and you have 3 minutes once you've got settled. And
right, no, I'm fine. You'll have to excuse my attire, but I didn't have any idea of this until about 10 minutes before you were due to start. So, and that in itself, I suppose, speaks volumes really on the parish council's sort of take on this whole situation. The one thing we can see that the planning department are constant at is the inconsistencies of some of the decisions that have been made recently in the village. And if this particular application is to go ahead, it's going to set a precedent for anybody that lives along that area to effectively say, oh, great, we can build a bungalow in the bottom of our garden. We have major concerns about access because the lane in question on the plan there is actually a private access to Glebe Farm. There is access via a footpath down the track because the footpath comes down off the main road and then into the field to the left as you come down the lane. The parish council obviously own the tennis courts and the allotments, and there is access granted for allotment holders and people using the tennis courts. The applicant at March House, we have had a lot of issues in recent months with taking advantage. You say about the fact that there is ample parking. This evening, as I was on the way home, they're doing building works as far as replacing fences, etc. at the moment, and he was obstructing the track down to Glebe Farm this evening. He's regularly parking the excess vehicle at the back of the property, which is actually on the parish council ground, with no prior notification. Would you mind if I just park here for a couple of days? There's never anything like that. The gap you saw in the fence with the big mesh fencing in place, as far as we're aware, there wasn't a TPO on it, but there was an oak tree there which, judging by the girth of it, I would have said was getting on for a couple of 100 years old, which was just taken out. And as far as we know, no permission was sought. It was just taken out. It wasn't even looked at to see if there was any TPOs on it or anything like that. The trees at the bottom of the plot, which are actually in the parish council ground, they've all been chopped and done with no prior notification. Going back to the parking space, sorry, I'm wandering here because obviously I didn't have time to prepare anything. You say there's ample parking. If this dwelling is put at the bottom of the garden, there's regularly between 6 and 8 vehicles at the front of the house. Now, they might have conveniently disappeared when somebody went there to check out the planning application or whatever, but there's at least 2 Range Rovers in there all the time. You've got 2 transit tipper-builded lorries, various other vehicles. It's got to the stage now where they are always constantly parked, half on the pavement, half on the Clacton Road, so they're obstructing the main road as well. What else have we got? Yeah, well, I think from my point of view, that ought to be enough. But it's just totally out of keeping with the area, and nobody else has got a miniature bungalow, if you like, at the bottom of the garden. When we consulted with district and county councillors and the parish council as a whole, we are all of the opinion that, in our minds, an annex is your main dwelling, and it's like you convert the garage over to provide more accommodation or whatever. This is a totally separate standalone building, so how can that be classed as an annex? Or has something changed and, we don't know about it? And again, going back to my opening sort of gambit, if you like, with regards to the inconsistency, this is probably, it may be not relevant, but from our point of view, it's very relevant. If you carry further down the lane towards Glebe Farm, there's a plot behind the allotments on the right-hand side. And a recent, just on the bottom left of the screen, that area there extends all the way down, right down to Glebe Farm. An application was put in and refused, and then appealed, and then refused again for an eco-friendly dwelling to go in there that has absolutely no bearing, no impact, no cause for concern to anybody whatsoever. This one, the people next door have put in various complaints about it. I know for a fact that Glebe Farm have expressed their concerns about it because of the access. It's got to the stage now where the parish council have had to put a barrier back across the entrance to the allotments to stop this guy incurring and using the space behind the allotments for his own personal use. So we would respectfully request that you refuse this application. I'm sorry, I've gone over 3 minutes.
It's all right. Councillor Nichols next for his 3rd appearance tonight.
Thank you, Chairman, members, officers, and all the various helpful comments from my colleagues sitting around the room. I've been asked to speak briefly on this on behalf of Thorrington Parish Council. They feel that this proposal is disproportionate building. It represents overdevelopment on the site. There is a total lack of access to it. And that, is this really a dwelling or is it going to finish up as an office. That is the fear, and I obviously can't express an opinion on that, but the parish council are adamant of their views. The house, March House, is already a 4-bedroom detached dwelling with parking for 2/3 cars on the front area. There is, as you can see, no side access whatsoever to the annex, and any people wishing to go and live in there would, I think, probably have to go down that narrow pathway alongside March House or through March House itself. There is a total lack of reasonable access to the rear and the side. The property, they feel, will be used as a business, which the owner of March House is currently using March House as his business. The parking problem, as has been expressed by Councillor Sadler, is, I think, causing great deal of problems, because a 4-bedroom house plus an annex, so you're talking, if the annex is used as a dwelling part, you're talking 5 bedrooms, so how many parking spaces do you need for a 5-bedroom house? 3 minimum? There is not enough room at the front of that property or in the grounds for parking to be available to suit the amount of accommodation that's provided on this site. And I endorse Councillor Sadler's remarks and ask you to refuse this application. Thank you.
Right. Thank you very much, Councillor. And now, finally, Mr. Ron Cross, the agent for the site.
Mr. Chairman, members of the committee, thank you for hearing my comments. Right, I want to address a few points raised by the previous speakers. First of all, in relation to the track, it's not proposed to be used at all, because this proposal is for accommodation for the owner's mother to look after his children. This is a very sad case that the accommodation is required because my client's wife has a severe mental illness and has left the property, and he's left with 2 young children which have to be looked after while he's at work. He doesn't work from home, he's a bricklayer. He does his paperwork at home, like all self-employed people do. But while he's a bricklayer, somebody has to care for his children. And his mother has kindly agreed to do that for him. Now, she needs separate accommodation. She's got a partner of her own. And this is the sole purpose that this building is required. No other reason. It won't be converted into an office. It's purely accommodation which will be ancillary to the property. It will never be separated. As been pointed out, there's no access to it for vehicles. It's got sufficient amenity space, so has the existing donor property. But there's no proposal to convert this into an office or to separate it from the donor property at any stage whatsoever. And we're quite happy for that to be made clear in any approval given. As far as access is concerned, it's quite adequate access down the side, either from the house or down the side to get to that property. And after all, the person who will be living in it will be the client's mother. So it will be like she'll have free access to both properties, either through the house or around the house, to live in that accommodation proposed. Now, as been pointed out by the planning officer, originally it was going to be a two-storey dwelling. We've listened to what their concerns were, and we made it into a single-storey dwelling. And it was mentioned that the heights of the eaves would be higher than the fencing. Well, the top of the windows will be actually 2.250 above paving level. So with all the fencing around it, you can't actually see into the track or into neighbours' properties or the land at the back. There's going to be no link between the proposal, the track, the land at the rear, the neighbours' properties, or anything of that nature whatsoever. So the comments that have been made are totally irrelevant. As I say, the amenity areas are quite adequate, and they leave suitable amenity areas at the rear of March House. I think the only thing I'd mention is the tree that was mentioned in foregoing comments. That was proved to be rotten, so that was taken out. I'm not sure whether there was a preservation order on that or not. That is an issue for another time. But as far as I'm concerned, it was taken out because it was rotten. So really, I'd like you to bear in mind the comments I've made about the location of it, the effect on the neighbours, the effect on the fact that we've reduced the height of it, and the compassionate grounds I'd like you to take into account on behalf of my client. Thank you very much.
Thank you, Mr. Cross. Any extra points? Yes.
Yeah, it might be helpful perhaps if I try and pick up a few of those comments for you, Chair. There were obviously, there's clearly some concern in the village from Parish Council, but quite a few of those issues I think that were mentioned are not strictly part of your consideration for this application tonight. So the things mentioned were about use of and blocking in the track. Well, obviously that's a private issue between the landowners. It has happened prior to planning permission being granted, so you can't really link the two things. The removal of a tree, we can certainly look at that if there should have been permission for that, but I'm not aware there was a TPO on there, and if it was rotten, that would have been justification. The number of vehicles kept at the property, again, that's not really related to this particular proposal. And in terms of the potential business use of the property, if there is concern there's a business there, then certainly our enforcement team can look at that and review that. But it's not uncommon for people to run small businesses from their homes. That's a sort of modern way of running many businesses, but we could look at that. But if we focus down on the proposal that's before you this evening, it is for ancillary accommodation to the existing dwelling. It's not for the establishment of a new dwelling. And officers would view the lack of an independent access as being positive in that way, because it can't be accessed, completely independently. The two things are sort of linked by virtue of the need to access through or close down the side of the property. Certainly no vehicular access to the back. And it's perhaps just worth touching on what would be permitted development. So why does this actually need planning permission? Because obviously most properties have permitted development rights to build quite substantial sheds or ancillary accommodation for use, in association with the main dwelling in gardens. So it could be up to half the garden area could be used for that, the rear garden area. And so long as it was no more than 2.5 metres in height, it could be that close to the side boundaries. So if this was a flat-roofed property building in the rear garden, then I suspect it would actually be permitted development and wouldn't need planning permission. So it's actually the addition of some height from 2.5 to 2.6 to the eaves and the introduction of a pitched roof that takes it over that threshold. I think that covered all the points, Chair.
Thank you for that. Could you put the elevation drawing? Because I take your point about the height, because in the statement it says it's 4.9 metres high to the pitch, as against the 2.6 that you were talking about.
Sorry, Chair, it's 2.6 to the eaves, and 4.9 to the ridge.
Right. Councillors, up to you. Yes, Councillor Alexander.
I'd like to thank you for bringing the attention of the tree back to us. That was one question that I was going to
Microphone.
ask.
Microphone, please.
So I do apologise for that. Okay, the tree. Obviously, you weren't aware that that tree was in existence because you basically cited that. And that the thing that's concerning me is that the fact is that this has been cut down because somebody said that it was rotten. Who had the authority to say that? And was it a tree expert, a tree officer? Was there a TPO in place on this tree? And who gave it permission to be cut down and grubbed out like that? It was obviously in the way of the development, and if that had those things, this development wouldn't be going ahead. Sorry. So I would like some information on that, but how are we going to do that? Because we're making the decision before us, and that information is not before us tonight. So could you give me any information that you have to hand, please?
Okay. If there's concern that a tree that benefited from a preservation order has been felled, then that would be an offence, that would be an unlawful act, and I can certainly take that away and we can investigate that. So we can check the records to see if there was a tree in existence there, and if there was, then we can pursue that. But I don't think that needs to stand in the way of determining his planning application. That's quite a separate issue.
Right. Councillor Everett.
Thank you. A couple of questions. In terms of the amenity area and the standards that we normally accept, I think we've established that there's going to effectively be the equivalent of 5 bedrooms in this 2 properties. What would we expect for amenity area, and has that been succeeded in being? And the second part to my question is, in the surrounding area, what is the density of the surrounding properties? And would this be the same sort of density, or would it be different to the surrounding area?
Okay, the officer's report, I'm pretty sure, I can't spot it now, tells us that the amenity area is still over policy, over the policy requirement, which would be 100 square metres. 6.11, is it? Thank you. Yeah. So a minimum of 100 square metres will be retained. In terms of density, obviously we're not introducing a new dwelling here, so in terms of dwellings per hectare there would be no change. But there would be more development on the site, obviously, than there is now. I haven't measured the density in the area. Looking at that aerial shot, the gardens along there are comparable. Most of them are fairly free of garden structures, but actually they could put garden structures over half their rear gardens without the need for planning permission. So I'm not sure if that completely answers your question.
Councillor McWilliams.
Thank you, Chairman, and thank you for that piece of information. That was useful as well. Just out of interest, would there ever be the need to give a condition? Because if this was made smaller, it would come under permitted development and we wouldn't necessarily have it before us. That's just a thing that I just wanted to pick up on. But it is here and it is there for a specific reason. Would it apply the same as perhaps a farm worker's cottage is built for a specific purpose, and then once that farm or whatever is the reason for it being there is no longer, it then has to be literally demolished and taken away. Is that something that we should be looking at here as well, if we were minded to consider permission for it? Now, the other thing that I also understood from our officer that was with us this morning, the electricity, sewage, water, all of that has to come through the existing property. Is that the case? So, you know, I'm just wondering how that works, because I did notice that there was something had been changed in the garden, and you could see where there's a strip of dead grass, so it looks as though they've obviously been thinking about doing something there. But is that the case, that you have to have all your electricity supply, your sewage supply and water supply all goes through the same system? Can I just confirm that, please?
Yeah, thanks, Chair. In terms of comparing it to an agricultural workers' dwelling, that condition you were describing would be for a wholly separate dwelling, where you were granting planning permission in a location you wouldn't normally allow a new dwelling to go, but there was a special justification. Although the agent suggested when he spoke that there were sort of special circumstances in terms of health issues and caring responsibilities, the officers the application hasn't really been made in that way. It's a straightforward application for ancillary accommodation. Yes, there are some personal circumstances kind of prompting that. I don't think it's a particularly suitable case for a condition that, I'm not sure what you do, that limits it to this particular family, because I think either you need to come to a view as to whether this form of accommodation is acceptable or is too harmful to be granted planning permission. The officer's view is it's not harmful and planning permission can be granted. The condition that you would want to, we've recommended you put on, is that it should be ancillary accommodation, an annex only, and never to be an independent dwelling, but not for a temporary period, I think. And the second question about sewage, electricity, etc., I think those things are indications of whether it is acting as an annex or as a separate dwelling. So you wouldn't expect an annex to have its own sewage supply, its own electricity meters, because if they're behaving as one household, you wouldn't expect in most households to pay your own electricity bill. It's tempting with teenagers. But I think there's no law that says it has to be, all of those things have to necessarily go through, but it is a good indication of how they're living.
Councillor Brown?
Is it automatic? Is it automatic that, although you wouldn't put a condition on the family if their circumstances change, but would there automatically be a condition that, say, it couldn't be used as an office or business? That would be automatic, would
it? What's being applied for is a residential annex, so ancillary residential accommodation. Within any dwelling, an amount of home working can be carried out without there necessarily being a material change of use. So we would apply the same sort of rules to the dwelling overall. If there's a particular concern that this would, if you like, lend itself to an unsuitable use, I suppose for clarification you could put something on which specified, in the an informative, which said it's not for business use, but really you'd want to look at the whole unit, the whole planning unit, and apply, I think, the same judgments that you would apply to any other dwelling.
Yes, Councillor.
I think I can help with that. In the model conditions that are in the original document, which was Circular 1195, which is still used by the government, referred to in the NPPF, number 47 actually makes exactly that provision with a slight change to what you've written in here. It says, the building hereby permitted shall not be occupied at any time other than for purposes ancillary to the residential use of the dwelling known as. So that's the way we do that, just put the word residential in there. There are also personal permissions in here. I have to take advice from officers and whoever as to whether they're appropriate to be used or not, but there is such a thing as personal permissions, as actually John will know, because there's quite a few personal permissions up at St Osoph and around there. But they're used in certain circumstances. I'm not sure that it's appropriate in this, but I take guidance from officers.
Right. Whilst Kath's thinking of that, let me put it yet another question. If this was granted under GDO, there's a limit of applications that you can get granted under GDO. The officer did indicate there may be some further applications wanted on this property. Would this fulfil all the permissions under GDO if it were granted tonight? Richard, your mic.
Okay, in terms of the condition to make it personal, I don't think there's a planning reason to put a personal condition on. They're very unusual because either the development is acceptable in planning terms, albeit on balance, or it isn't. And personal permission, you have to remember that the development is, to all intents and purposes, permanent. It's a permanent structure that's being erected. You'd have to think about what it is about the development that would make it unacceptable in the long term, and therefore you'd want it removed, and yet you are willing to accept it in the short term for some personal reasons specific to that individual. I don't think it's necessary in this case. The officer's view is that the development as it stands is acceptable and should run with the land. I believe there is another planning application before the council for a single-storey extension to the rear of the dwelling, which fills in the... I bet you... So here, I meant to check whether it had been granted or refused or was still current actually before I came in, and I'm sorry, I forgot. It is still current, okay. So I understand it fills in the space between that... There's a protruding extension there, and it fills in the sort of corner there. So in terms of amenity space, or impact on amenity space, where is that plan? There, it's this in here. So it's not significant in terms of eroding the amenity space here.
No, it's a question of if we were to grant this one, does that preclude any further permissions under GDO?
Okay, under permitted development, I'm sorry, I don't know enough about the history of the property. It's possible that, because I don't actually know whether this piece is original or not either.
Right, okay. Councillor Everett?
Can I ask, would we be able to put a condition on the prevented permitted development rights? I mean, I'm thinking particularly of the second-storey nature, potentially, of this building. So we could do permitted development, say no permitted development rights there. Could we do it elsewise?
So the annex itself wouldn't benefit from any permitted development rights. I'm not sure what you have in mind in terms of removing any other permitted development rights for the main dwelling. I'm not sure how you would what they might be and how you would justify them. I mean, if they needed planning permission for a single-storey extension here, that suggests to me they've already used the PD that they could have for extensions to the dwelling. Obviously, this falls in a different class. This is an ancillary. This is a building within the curtilage.
Right. Okay, councillors. are we in a fit state to propose anything at the present moment? We've chewed over a lot of questions. Anybody willing to propose anything? If not, we continue the questions. But yes, Councillor Holmes.
I propose that we approve it. It's like a shed, really.
Yeah. Okay.
Expensive shed.
Okay, so we've got a proposer. Do I have a seconder for the proposal? We have a seconder for it. Good, right. Now you know what's in front of you. Any further additions that you feel need adding in view of what's been said at this stage before we vote on it? Yes.
I think Councillor Everett suggested earlier adding in to the condition number 3, occupied as a residential annex ancillary to March House, just for clarification.
Yeah. Residential. Right. Nothing further, in which case I'm going to put it to the vote, just test you out. So I have a proposer, Councillor Hones, Councillor Brown seconded, that we approve this with the conditions as on 78, except that number 3 has a residential annex in the title. Those in favour, please show. 1, 2, 3, 4, 5. I'll add my 2 penneth, 7. And those against, please show.
Show me as abstaining, please.
In that case, and those abstaining, 1, 2, 3. Right. In that case, it is approved with the conditions as amended. Thank you, councillors. That concludes our business this evening. Thank you all very much. And before we meet again, just to remind you that we have got a scheduled training session. You will have all received an email.
10th of July.
10th.
2 o'clock.
And I think it's one of travelling round the patch. So you had your apologies from your chairman for that.
You're not coming?
Yes.
You're not coming?
I'm in a conference in Glamorgan.
I see.
Serious point about the bus.
What, today? Didn't have aircon.
I thought you meant last